Yes.
Lordship, may I ready to mention a matter for inclusion or restoration application? May I permit to mention one Milord FMET for it?
And leave to appeal, leave to file the appeal without certified copy.
When the order is passed,
Yesterday.
have you applied for certified
Yes,
copy? Have you annexed the copy?
No, I have not yet done it.
Next it.
And I will annex them.
Your Lordship, may I permitted to mention this matter? These are 5 matters, similar matters for admission, Your Lordship, first appeal.
Admission, first appeal does not require admission. First appeal does not require admission, it is automatically admitted.
Your Lordship, unless a formal order is to
No, who says? Under what law you are talking about? Section 96 does not permit any formal law to be, order to be passed. Sorry?
Lordship, may I be permitted to mention one thing, Lordship?
Yes.
Lordship, today's item number 279, Lordship. First appeal, copy, paper book is ready. But I waited yesterday.
We will keep 1 day, we will keep 1 day for hearing, don't worry. Let us wait.
Lordship. Today's item number 270.
Yes. Yes, call the list.
My lord, in item number 1 to 6, my lord, I appear on behalf of the petitioners, my lord.
Why, sir? You are a young man. Why you do not appear yesterday?
My lord,
Can you send some of your friends for that?
my lord, due to some urgency, I had to leave the court yesterday, my lord.
So why it is not possible that not pressing the application by a third advocate. You
No,
are the
I-
advocate and record. You must
Correct.
bear the
No,
responsibility for that.
My lord, I bow down for that,
It
my lord.
never happened in the Calcutta High Court.
My lord, I bow down for that, my lord.
It is not pressed.
Grateful, my lord.
5 items are there.
Yeah.
6. ওখানে একই হবে order?
Yes. You are appearing in how many items?
My lord, in item number 1 to 6, my lord.
1 to 6. Yes. All are not pressed.
Grateful, my lords. Grateful.
Give your memo of appearance.
Yes, we are given. This is not.
Item number 7, my lord, appeal for the appellant.
What?
Appellant. Now, my lord, yesterday my junior told me, my lord is of the view, my lord, this appeal is not maintainable. Now, my lord,
I do not know.
that was conveyed to me.
Yes. I just asked. This order has been passed by
The eviction
the
of.
eviction officer.
Yes,
So I just thought under the special law whether the appeal lies.
yes, my lord, the Act, Airport
I
Authority.
did
of
not
India.
say the appeal is not maintainable. I say that show us the provision that it is maintainable.
My lord, kindly sees, my lord, 28K. বইটা একটু দিন। My lord,
There is a tribunal also.
My lord, there was initially tribunal, but
Yes.
there were in 2021, it has been substituted. My lord, and my lord, now appeal lies to High Court.
28K, what it says.
My lord, any order passed, my lord, under this chapter, my lord, which is, my lord, parameteria, my lord, to say, my lord, under the Public Premises Unauthorized Eviction Act.
To the High Court. 15 days, it is filed.
My lord, within 30 days. My
So-
lord, limitation is 50
15.
and my lord, 30 days, my lord, outer limit, within which I have to file.
Then will you not file an application for
My lord, that's why
condonation?
similar to
That
there
is
is
not
no
here.
applica-
That
because
is
there
not
no
here.
application.
And if it is 30 days or beyond 30 days,
Beyond 30 days, my lord, statute says no leave can be granted.
outer limit, then
Outer limit. So, my
you
lord,
are within 30 or beyond 30?
Within 30.
Within 30. What is the date of the order?
My lord, the order is, my lord, dated 3rd of June 2024.
And when the appeal is presented?
Appeal to file was slip to cover.
3rd July.
3rd July. My lord, just on 30. No. But there was a confusion where to go.
On 30th. First day to baad jabe na?
Excluding.
First day will be excluded for further competition. Five, section 5,
Yes, my lord, for that 15 days, my lord, I shall.
you have to.
Section 5 will stay. My lord, I shall file a stay application. I tell you, lordship, my lord, the question which I raised, my lord, today.
First thing is pass on the I will, the trouble of section 5, condonation may not be there.
My lord is always.
No. Where is your section
My
5?
lord,
Come.
that is not there, my lord. I shall.
Yes, it appears that the appeal is filed under section 28K of the Airport Authority of India Act 1994. And question was raised whether an appeal against the order of the eviction officer is maintainable before the High Court. So, in view of this aforesaid provision, the appeal lies to the High Court, but it appears that the instant appeal has been filed beyond the period of limitations provided therein, without accompanying an application for condonation of delay. So, in such view of the matter, let this appeal go out of list to enable the appellant to take an appropriate steps. Take out immediately.
Immediately.
I'm here for the appellant, my lordship. Landed senior will appear through this.
Directly.
Lord, item number 8.
There is a, oh, you have corrected it. Valuation and all, everything is over.
Lord, the corrections have been done, my lord.
Yes,
Lord,
what,
Actually, my lord, for the
who are you in the trial court? Defendant or, oh, he's appearing. Defendant or appellant? Plaintiff in the trial court?
Lord, I was the defendant before the trial court, my lord.
Defendant, judgment of affirmance or reversal?
Lord, it's a judgment of, my lord, affirmation by the first appellate court, my lord.
Yes.
Lord,
Suit
will
for?
kindly seize the,
Suit for? What is the suit for?
Lord, it's a suit for eviction. Lord, I was the
For?
tenant. Lord,
Tenant.
I was for the tenant, my lord. There was an agreement between both the plaintiff and the defendant, my lord, for a monthly tenancy, my lord, which was prevailing from 2003. Now, my lord, on 2017, Lord, in 2017, my lord, I faced an eviction notice where the plaintiff for the first time came up on the ground that he reasonably requires the suit premises, my lord. And on the basis of the reasonable requirement, my lord, the learned trial court applies the test of comparative hardship, my lord.
Did not
and
apply or apply?
Not apply the test of,
How? Then it will go in your favor.
my lord, it did not go in my favor, my lord. Lord, upon applying the test of comparative hardship, my lord, it was found that the plaintiff is in a greater need of the premises than the defendant. My lord,
Okay.
this finding, my lord, was thereafter affirmed by the first appellate court, despite there being a specific.
Do you have the copy of the commission report? Commissioner's report? There must be a commission held.
Lord, the evidence which was held, my lord, those depositions are there, my lord, which are annexed in my appeal. Lord, will kindly
What is the
also,
composition? What is the composition of plaintiff's family?
Lord, the plaintiff's family, the plaintiff number 1 and the plaintiff number 2, my lord, are related. The plaintiff, they are family members.
They are the full blood brothers.
The plaintiff number 1 and 2, yes, ma'am.
Yes.
And
What is the composition of the family? I just wanted. Plaintiff number 1 has how many?
my lord, that is not stated, my lord, anywhere in the plaint.
What are you talking about? It has to be stated and it has to be there in the evidence also.
But will kindly come. I think led by my senior, my lord.
Oh,
With your
you have
lordship,
senior also. The junior most is standing before me, then immediate senior, and then the senior most.
Sorry.
Is there any other person above you? I asked 2-3 questions. I asked him that please tell me the composition of the plaintiff's family.
Yes. Composition of plaintiffs are, my lord, 3 brothers, my lord. But if your lordship, my lord, permits me to just say this, on comparative
I
hardship.
understand. You need not have to say. I am conscious. The
Yes,
concept of comparative hardship,
It's not
that's
there
why
in
I
understanding.
ask these questions. I know. You need not have to argue comparative hardship.
So that's the
If
basis
the
of the.
if the ultimate decision appears to be correct,
Yes,
we
my lord.
can substitute our own finding. There is no difficulty.
My lord, the learned trial court, my lord, gives
Wrongly applied comparative hardship concept.
and appeal court, my lord, affirms it, again applying.
That's a very wrong on their part because the statute does not contain
Exactly,
any
Lord.
provision. I know. But tell me,
Yes, my lord.
yes, what is the composition? I am aware what you are going to argue.
I appreciate, my lord. I appreciate, but you know, lot of evidence, lot of facts, my lord, that has to come on. You know, somebody has to see it, my lord. You know, kindly, my lord,
Don't worry. Show us. That's why I say composition. Tell us.
Yes. But I'll just, my lord, tell you, lordship.
Plaintiff number one, family consists of himself, his wife,
His wife and, my lord, brothers. Now, my lord,
no, children. Tell me, children.
children, my lord, I believe
Business.
2 children.
For the purpose of business.
Oh, this is for the purpose of business.
This is, my lord, for the purpose of business.
Okay. I got it.
This for the purpose of business are cases that, my lord, he has, my lord, other properties also that he is carrying on business. We've given evidence. Now, my lord, all of
Just
that.
take a rest a while. Just rest a while. Let us hurriedly go through the plaint.
Yes.
Yes, yes.
Milord, if your lordship sees the trial court decree, Milord, facts not considered, evidence not considered. Plaintiffs are cousins, they want this for their business. The Milord, appeal court decree.
Plaintiffs are cousin, the plaintiffs are full blood brothers. The name
plaintiff
of the father is one and the same.
Rajesh, sure. Milord, kindly, Milord, if your lordship sees the
Oh no, sorry,
cousins, Milord.
cousins. No, you are correct.
Plaintiff number 2, Milord, has other brothers also. There is joint business in the same property. There is a petrol pump in the vicinity. Milord, there is no finding of reasonable requirement. Learned trial court, Milord, doesn't, Milord, consider facts or evidence. Learned lower appellate court, Milord, says that is, yes, I admit, but that's the style of writing judgment. And then both courts affirm a finding on comparative hardship, which is beyond, Milord, the statute. And your lordships, Milord, have held so, Milord, on numerous occasions. It's really turning the statute the other way around. Therefore, no adjudication in an eviction suit. And same property has numerous other rooms.
What? Same property has?
Numerous other rooms, Milord. One
No,
is
no. He is talking about only 3 shop rooms.
Yes.
One is in occupation of the plaintiff number 1.
Yes.
Another is in occupation of another person.
Yes.
And
Plus
third
us.
is in occupation, in your occupation.
Yes. Now, Milord,
So
there's
he
a
says that I want to start my own business independently,
yes.
and I do not have any shop room there where I can do it.
But there are other floors of the same business.
Can a tenant dictate the landlord that what will be best suited to your
No,
business?
I'm not saying that, but this,
That is what you say in the other house. He
He-
wanted a shop in the ground floor or a first floor accessible to the public.
Yes, there are, Milord, on the upper floor, the whole upper floor is there, whole basement is there, and Milord is already running
Can a business be run in the basement? What are you talking about, Mr. Chaudhary?
No, I understand, but
So,
Milord, there Been adjudication.
Nobody would be able to know that there is any business activities going in the basement.
No, I understand. That I do not, I don't Milord, for a moment say so. But Milord, there must be an adjudication. This is Milord on a ground which is not even Milord there in the statute. And your lordships have repeated.
No, I understand what you say. You have the point, no doubt about it. But after all, in pursuit of a justice, we have to see.
Yes, Lord, may I
Go on.
humbly submit this? I totally understand your lordships feel that a person wants his own property. That's there in every tenancy matter. Lord, equity follows the law. Law is, Lord, you have to come and prove it's a protected tenancy. That's why, Lord, I'm only praying for an adjudication, nothing else, Lord. In fact, if your lordships, Lord, remand it back for a decision on merits within a month or so, Lord, I would be more than, Lord, ready for that.
No. Suppose, Mr. Chaudhary, if there is a sufficient evidence which is there,
yes,
then there is no difficulty.
Yes, but
High
Millard,
Court can.
Very well, Millard. May I, Millard, give notice and your lordship looks at the evidence tomorrow or day after tomorrow? And if your lordship
We are
finds there is
looking into the
sufficient
evidence.
But I must have a chance to place my evidence and Millard, that must be considered and disposed of with reasons. Learned trial court doesn't give any reasons. Learned lower appellate court says, yes, I appreciate that, but that's the style of writing judgment. And then both courts will not hold on the basis of comparative hardship. Millard, there must be an adjudication. That is my only, Millard, aggrievement, because whatever evidence is on record is really not considered. Kindly, Millard, please look at the division, Millard, the learned lower appellate court judgment. Millard, I will just point out just two paragraphs. Millard, paragraph 2 on the second page, on page 11, Millard, paragraph 2 is, Millard, style of writing judgment. So on that basis, from Shiv Kumar Chatta, everything goes out of the window. And then, Millard, paragraph G, below that is comparative hardship. And G, Millard, really is the conclusion of A to F. And that's the end of the judgment. So, Millard, 95% of the judgment is, Millard, contrary to law. And I'll show your lordship the trial court judgment. That is, Millard, equally, Millard, not perverse, not considering, Millard, any evidence. Millard, my humble prayer is, I appreciate, Millard, equity. I appreciate a man must have his own, Millard, place. I appreciate, Millard, the anguish of, Millard, a landlord trying to get back possession. But when the statute says you have to give a notice on a ground and prove that ground in court, it's a protected tenancy. Then, Millard, without adjudication, kindly see the appeal court judgment. Millard, paragraph, if I may draw your lordship's attention to paragraph 2. So far as the format of writing judgment or contents of judgment is concerned, learned counsel argued that evidence is not discussed in the judgment by the learned trial court, whereas learned counsel for the respondent argued that the reference to some statements of witnesses made during their deposition and cross-examination shows that the learned trial judge has read, understood, analyzed all the evidence, and that there is no law, my Millard, kindly see this, and that there is no law mandating discussion of all evidence. There is no denying the fact that the learned trial court ought to have discussed all relevant evidence in the judgment to clearly reflect the thought process, reasoning, and logic that led to his findings clearly. Learned trial court has erred in not denying so. But the appellate court ought to be considered with the finding of the learned trial court and not on how the judgment could have been better written. And from that view, let's analyze whether the finding of the learned trial judge was lawful or whether it calls for interference. So, Millard, this is a classic case of remand. Now, Millard, please come into paragraph A, below that. Factual aspects. A, Millard, relationship of plaintiffs argued, etc., etc. B, C, D, E, and then, Millard, kindly see G. if we, after analysis of A to F, if we look into the question of comparative hardship of parties, so far as the question of availability of alternate accommodation, this is business. Is concerned, defendant admitted during his cross-examination, he owns 2 shutter shops at 9th Mile. Milord, what defendant owns? So admittedly, he owns multiple shops in a commercial area, one of which is vacant. Parties have admitted the following facts. Admitted facts need not be proved. Plaintiff, the building where plaintiff resides is residential, surrounded by residential. There is no suggestion that residential business has any shop. It is admitted by defendant during cross-examination, he owns such and such. Then Milord I, and then Milord 3 judgments noted, and paragraph 11, without reasons again.
Everything you are arguing. What is your cross-examination to the plaintiff's first witness? There are many things he said in the examination in chief, and there is no cross-examination. I am just reminding you of our off-quoted judgment of Justice P.N. Mukherjee, AEG Carapiets. What you have done? Yeah, 1961 Calcutta.
Yes.
What you have done?
That's now followed by Supreme Court also.
And there is nothing which has come out. You have not said. He says that I do not have any accommodations. You have not cross-examined. What is the rule of evidence that has been decided in Carapiet's case? That he not only you have to take a denial or whatever, they put a question to the plaintiff's witness about their assertion in the plaint, but also you will put your question what defense you have taken.
Yes, but Milord, to show your lordship,
You have not said, you are talking about in a near vicinity, there are many houses, all these things. But I do not find there is any kind of a question or the cross-examination which you have put. Not even, only you say ground floor, I think basement, 600 square feet, sufficient place, everything you put it in the cross-examination.
He is the plaintiffs are doing business from not the next room from the same premises.
No, that he says it is for the plaintiff number 1 who is running a business. There is no, he says whatever, he has obtained a trade license there, but he says, I want to separate my business, I want to start my independent business.
But he has a petrol pump very close.
What is this, Mr. Chaudhary? One is running a shop. It does not mean he cannot expand his business. He can run a multiple business.
Yes, but
for the multiple business, suppose if he's having a petrol pump, he is having 5 stationery shops. He is having 5 machinery shops. Now he wanted to establish a clinical, the establishments for the purpose of the testing. Will you say that he has so much of, let's say, business, he cannot set up a clinical business?
The question is, does it satisfy
the question is, for what business he want?
He wants to sell small toys, flyers, etc.
Whatever he wanted. Nowadays, everything, the toys are more lucrative business.
Yes, but issue is, has there been may I show the cross-examination?
Yes, please, I have read. I read it.
Yes, but if your lordship, very well, if your lordship has read it, I'll be able to show in great detail later.
Please come to paragraph 6, page 200.
But I would also
of the examination in chief. What he says?
Yes.
Paragraph 6 and 7.
No, this is kindly see that I have completed my studies.
Correct. You read that and then you come to the cross-examination. Please tell us that where you have put a question.
Very well. I'll just show you.
It starts from page 206.
I'll just show your lordship.
Please read
kindly
and tell me where you have put a question.
Kindly come to the second page, of the deposition.
No, forget about second page. I am talking about your cross-examination part. You have read this paragraph 6 and 7. Just he says, I do not have any place to run the business. No difficulty.
Page 206,
Please come to 206. Please read.
There are trade licenses, third line, there are trade licenses issued in favor of Vijay Gupta as proprietor of Art Emporium and my father Rajeshwar Prasad as proprietor. I have no document showing separation of business with my
And
father.
he's by the name of Bikram. Remember,
Yes, yes.
he's talking about Bikram. He says
Yes.
about Vijay is plaintiff number 1. Plaintiff number 2 is a
So,
Bikram.
Milord,
He want
there
him.
is- Milord, then he says, I have renewed trade license which stands in my name. It shows he's also.
No. He
No,
says,
no,
that is what he says, that I want a separate shop room. I do not have. I'm just working with my father and all everything. He wanted a separate showroom to come. Where is a obstacle in the law?
Milord, if I may humbly submit this, Milord.
The worst case I can tell you of the division bench or by Justice A.M. Bhattacharya.
Milord, may I just say this?
If
a
I am not
man
wrong,
wants-
it is 86 or 87 CLJ.
I'll Milord, look it up, Milord. If a man wants to run a business and he has Milord 2 properties, he's running from one, he says, I want to run a new business. That doesn't ipso facto give him a right to a decree. That's Milord my submission.
No, that they just Mr. Chaudhary, there is a distinction between the two facts.
Yes.
One is what you say, that he has a shop and he wanted the another shop, then he'll have to prove that how his business has grown, and there is for the purpose of an expansion of the business, he wanted an additional accommodation to do it.
And his present
Please.
insufficient.
There is another line which says that yes, I have been running a shop, but in the name which is there in the name of another person, or who is doing, the another person is doing, he is accommodating me so that I can run it. This is my property. I wanted to run the business from my own property. I want to separate. Then why not? Why not? He will be permitted.
May I do this, Milord? May I just Milord,
Why
research
not?
on this and come back tomorrow?
Read it very carefully. Read
And
it. I give you an example for that judgment of Justice A.M. Bhattacharya, where what happened on this, that a gentleman filed a suit for eviction of a tenant on the ground that his son is staying at Canada, and he wanted to come back to his motherland, India. But because of the dearth of accommodation, I cannot accommodate him. He cannot come and live with me. The suit was filed. The defendant took a plea that the son is a permanent resident of the Canada. He has already renounced the citizenship of India. He has taken a citizenship of Canada. He has purchased a lot of properties. So there is no intention to come and live permanently in the house. Justice A.M. Bhattacharya quoting 3 very, very, the notable, the concept. One was one was Rabindranath Thakur's the poem that is Sonar Bangla. Or it says that if I have to take birth, I would wish that I take birth in the land of Bengal again and again in my all lives. And the second one was the incident of the Ramayana, which says that when Ram vanquished Ravana, then the Lakshman told, big brother, the golden throne of Sri Lanka is at your disposal. You go and rule it. He says, no, I would prefer my motherland, Ayodhya, than the Sri Lanka. So he preferred the motherland. So the decision was that if somebody wants to come back to his motherland, which he always have some kind of an attachment, then in that event, the law cannot stand in the way. Similarly, a person who wanted to start his business in his own house, he wanted an independent way of doing the business. He does not want that there should be any kind of a, the partnership or any kind of an interference from any of the brothers. I want to stand in my life alone. Then can a law stand in the way of achieving this desire, which is a more reasonable and more pious?
I will look it up and come back tomorrow.
And then also Justice Bhattacharya quoted the sloka from the Gita also.
Read the judgment.
By reading is the Janani Janma Bhumishya Sargadapi Garyashi.
Grateful.
Please read that judgment. It's a worth reading judgment.
Yes, yes.
Come tomorrow.
Yes, grateful.
And you are right, there is no concept of comparative hardship in the West Bengal Presidency Act.
Yes.
That you are correct, no doubt.
Yes, but I agree, my lord, I have to show some light, otherwise. my lord,
Show us that what you have said. Let us
Yes.
see.
Great.
Not today, kal ke rakho.
Grateful, my lordship.
My lord, item 9, my lord, I beg to appear for the appellant. My lord, I'm sitting in a bar association room, my lord. That's why, my lord, I'm just praying for not today. My lord, I'll do it tomorrow.
Refused
My lord, then, my lord, I'll have to start, my lord.
because I don't encourage begging.
I'm sorry. I'm for the appellant, my lord. This is, my lord, I'm plaintiff appellant. I lost before the lower appellate court. My lord, suit for my lord, only my lord, suit for permanent injunction, where my lord, suit court has said that since you are not having the title and you are not in a possession because of the fact that your name is not up in the record of rights, hence you could not show your possession, hence my suit was dismissed, and appeal court has also, lower appellate court has also affirmed the suit court's order by saying that yes,
So you want to appear tomorrow?
my lord, please.
Come appear personally tomorrow.
My lord, no, not personally, my lord.
Yes,
Well,
come.
I'll do it online, my lord. I'll do it online, my lord. Well, since I'm sitting in a bar association room, my lord, that's why I have prayed, my lord. Tomorrow I'll be doing it from any private chamber,
Okay. Yes, tomorrow.
my lord. I'm deeply obliged.
Yes, you are for?
Stay. We both are representing.
Where is the appellant? Yes.
Yesterday, the matter was called and was passed over for the day, but nobody appeared.
Are they not interested?
Section 5 is there. Oh, no.
Plea of adverse position was turned down. Where is Mr. Vikas Singh and Miss Ria Agarwal?
Yesterday they appeared.
Where are they?
Mr. Because Singh was report number 1, sent for him. Good note 2, sir.
Pass over, let them call. You,
Yes.
you just inform them. Call the next.
My lord, I beg to stand for the petition, my lord. Appealant. I'm extremely sorry, my lord, I could not attend yesterday, my lord.
Who are you in the trial court?
I'm a defendant. my lord.
Defendant.
And I failed to
Which is
file
the judgment of affirmance or reversal?
a reversal, my lord. I failed.
Reversal
Yeah,
means
I
you
failed-
you won in the trial
No,
court.
no, my lord. I failed to file written statement, my lord. And there is delay of,
Then it's a judgment of affirmance.
yes, my lord.
Say that. I was thinking
1431 days, my lord. Delay of 1431 days, and I failed in the district court also, first appeal also, my lord.
so it's a judgment of affirmance.
My lord.
So both the courts you have. So what is this
My lord, I'm in,
miscellaneous case?
I'm in the permissive position, my lord.
Permissive.
Now this in the trial court, my lord, it is in the execution stage, my lord.
So this is the second appeal.
My lord,
You have to show that it involves a substantial question of law.
my lord, my lord.
What is that? I just wanted. You said that you could not file a written
My
statement.
lord, my lord.
So your defense was struck off, or
It
I
is
mean,
declared
sorry, the suit was
ex
proceed
parte,
ex parte
ex parte, my lord.
under order 8, rule 10,
My lord.
order 10A. Was it under order 8, rule 10A?
They declare, but it is order was not mentioned, my lord, in the judgment. my lord.
You gave an evidence or you did not?
No, I didn't give.
So this is an ex parte decree.
Ex parte degree, my lord.
So, but it does not appear. This is ex parte decree.
Thereafter, my lord, I filed a stay application. There also I failed, my lord. Then I came before the honorable court filing
Not in this
revision.
council appeals in summons. Extra decree was passed against him.
Oh, so this is against order 9, rule 13.
My lord.
Say that. What was your defense?
Defense was, my lord, I'm this.
No, order 9, rule 13.
That I could not file because I was sick and there was pandemic also, my lord, thereafter. I'm 74 years old, my lord, and I'm in the,
What are you talking about? When the suit was decreed?
my lord.
What is the date?
Date was 33/2019, my lord. It was filed on
So
14.
there was no pandemic.
No pandemic, my lord.
So
But I was sick
these
during.
are all pre-pandemic
Yes, my lord.
situations. So why did you lead an evidence? Did you produce any documents, medical or so?
My lord, I had filed and I filed this 47 application also, but it was rejected by the.
Rightly.
Thereafter, I came to the honorable court also, filing CO, that
So
was
you
rejected. I have been directed.
have exhausted whatever
all the-
revenue,
all the
whatever
avenues.
avenue which is provided to you under the codicil procedure.
My lord.
And this is the last one.
Last,
So let it also go.
my lord. I'm 74 years old. I'm in the possession of land since 74, my lord.
But
Almost
as a-
50 years, my lord.
So as a permissive occupant,
Yes, my lord.
so you do not have any right. One has to go.
May I be given permission to solve the copy, my lord?
No. This is not the
we-
concept of order 41 rule 11. This is not a concept of order 41 rule 11.
With
The
with
service of the
any-
copy up to the district court level, I appreciate it under section 96, but High Court section 100, very difficult.
I'll prove my case, my lord.
Show us, argue. Let us see. What do you say?
I was in the permissive position since 1974, my lord.
Yes.
And kept by my father-in-law, respond number 1. There are 3 plaintiff in the original suit, my lord. And when this plaintiff number 2 and 3 were not even born, and I was requested by the family, this original landowner.
What is your relation with the plaintiff?
I'm just outside. There's just,
Outsider.
I was Bargadar for some other people, but they requested me to be help this to cultivate their land.
But
And I
you're
was
not a recorded Bargadar.
not recorded, but I had given application to the BLRO, Milord.
Yes.
But they didn't consider that because there was suit pending before the civil court jurisdiction, Milord. And I have been staying there since more than 50 years, Milord, with their request, Milord. And but unfortunately, Milord, because of my ill health, Milord, I could not file the written statement in the this original court where suit was pending, Milord. And I felt in other forum also, Milord, and it is the last forum where I could come.
No, order 9 rule 13, you have to prove that there are only two ingredients in order 9 rule 13.
Milord.
What is your ingredient? First is that summons were not served. If you can prove that summons were not served is one.
It was served.
It
Milord.
was served.
It was served.
Second is that you were prevented by a sufficient cause in not appearing on the day when the suit was posted for hearing. So why you did not appear? What is your
There was a junior lawyer representing me in the lower court, Milord.
Yes.
See, instead of filing this other application, Milord, she filed this application under 47, Milord, of CPC.
That is after the decree.
After the degree, after the degree.
I am talking about on the day when
She
the
could have
ex parte
exhausted
decree
that,
was passed.
Milord.
I am talking about that. Order 9 rule 13 does not talk about execution. It talks about the decree, ex parte decree. On the day when ex parte decree was passed, how you were prevented?
Milord, I could not file the reply, Milord.
So what can be done then?
I was sick, Milord. I could not come for the filing of affidavit, Milord.
In order 9 rule 13, did you produce the medical certificates?
Milord, I
produced?
had produced.
Did you adduce any evidence?
I had.
Where is the evidence? What you have said?
Doctor's evidence is there.
They have the order 9 rule 13 application with you?
I don't have. Milord.
Before filing order 9 rule 13, you filed an application under section 47
Milord.
in the execution proceeding.
No. Previously, I filed this application under 47.
Previously?
No. Prior to filing this order 9 rule 13. It was.
That is what my
Milord.
the judge is asking you that
Yes, Milord.
prior to order 9 rule 13, you filed section 47.
Yes,
Milord.
that has been done here. That has been disposed of. Very bad case.
Anything more? A recalcitrant litigant has innovatively uh, adopted all the tactics to thwart the decree for eviction passed against him, and ultimately approached this court with the instant second appeal, assailing the order of rejection of order 9, the application filed under order 9 rule 13 of the Code of Civil Procedure, and an appeal filed against the said order having dismissed on the ground of delay as well as merit. The suit for recovery of position filed against the appellant is to decreed ex parte in the year 2019. Yet, no steps were taken for setting aside the ex parte degree. Within the period of limitation provided therefore. Before we proceed to deal with the points involved in the instant appeal, it would be profitable to adumbrate the salient facts discerned from the record. The suit for eviction / recovery of possession against the appellant was filed before the trial court, and upon receipt of the summons, the appellant appeared in the said suit and asked for
Filing.
the leave to file written statement. They, despite such leave having granted and the extension of time being favored, no written statement was filed by the appellant. Naturally, the suit is posted for ex parte hearing, which spanned over 3 months. But there was no attempt on the part of the appellant to appear and intervene at the ex parte stage. Immediately after the suit was decreed ex parte, and taking advantage of the pandemic having struck globally, an application under section 47 of the Code of Civil Procedure was filed alleging fraud, coercion, undue influence. But the said proceeding was not pursued, as a result whereof the said application under section 47 of the code was dismissed for default. Since the execution proceeding continued thereafter, an application under section 9 or under order 9, rule 13 of the code, along with an application for condonation of delay, is filed, taking a plea that the appellant, being a septuagenarian and suffering from various ailments, was prevented by sufficient cause in not filing the said application within the prescribed period of limitation provided under the Limitation Act. Not a iota piece of evidence was produced before the trial court in support of the aforesaid contention, and therefore the trial court proceeded to dismiss the said application, which was further carried to a first appellate court, and the said order was affirmed. Next matter. It is submitted by the counsel for the appellant that the appellant, being a aged person, could not file the written statement, resulting into a suit being decreed ex parte, and therefore the court should take a lenient view in this regard. It is further submitted that the appellant is occupying the suit premises as permissive occupant since several decades, and therefore the ex parte decree would harshly affect his right unless set aside by the court. Lastly, it is submitted that the appellant was seriously ill and could not take steps within the time limited therefore, and therefore the court should adopt a pragmatic approach in this regard. Let us examine from the facts emanates from the record in order to understand the gamut of the arguments advanced before us. Stop. We are conscious of the proposition of law that Order 9, Rule 13 of the Code of Civil Procedure bestowed right upon the defendant to apply for setting aside the ex parte decree/order, provided the ingredients enumerated therein are proved to the satisfaction of the court. The language employed under Order 9 Rule 13 can be dissected in two parts. Firstly, there was no service of summons upon the defendant, yet the court proceeded to decree the suit ex parte. Secondly, the defendant was served with the summons, but was prevented by sufficient cause in not appearing on the day when the suit was decreed ex parte. It is undisputed that the service, that the summons was duly served upon the appellant, which would further be evident from the fact that he appeared in the suit and sought leave to file written statement, and also applied for extension of time to file the written statement. The plea has been taken under the second component of Order 9 Rule 13, providing for an impediment on the part of the defendant in appearing on the day when the suit was decreed ex parte. Obviously, this sufficient cause, the expression within court, the sufficient cause is not defined in the aforesaid provisions, in the Code of Civil Procedure, but receives its recognitions from a different judgments passed in the judicial parlance, and is construed to mean that though the defendant was vigilant, careful, and took all the steps, but was vigilant and careful, but because of the unforeseen circumstances, he could not participate / appear in the suit on the day when the ex parte decree was passed. We are conscious that the court, while ascertaining the expression within court sufficient cause, should not adopt a pedantic view or a stricter approach, or a stricter approach in finding the fault into the defendant, leading to a rejection of an application under Order 9 Rule 13 of the court. It is consistently held that the court should adopt a lenient approach in construing the sufficient cause, but should bear in mind that bear in mind the purpose, the object and purpose of promulgating their Limitation Act. Full stop. In order to construe the sufficient cause, which is also appearing under Section 5 of the Limitation Act, the court should also take into account Section 3 thereof, and an harmonization is required to be established in condoning the delay or setting aside in condoning the delay for delay in taking steps within the statutory period of limitation. Stop. Even if the court should adopt the lenient approach, but must consider the attending circumstances in the context of the facts pleaded by the parties as an equilibrium amongst the rights of the parties are required to be established and should not be used as a one-way traffic. The Limitation Act never destroys the right, but denuded a litigant to get the relief from the court on the basis of such rights. And in this regard, it is held in Catino decision that the court cannot shirk its responsibilities under Section 3 of the Limitation Act, even if no defense of limitation is taken by the other side. We are also conscious that the court should also bear in mind that the meritorious suit should not be defeated. But while taking into consideration the aforesaid aspect, the object and purpose of the Limitation Act should not be frustrated or rendered osseous. In order to constitute a sufficient cause, the court is guided by the factors relating to the human behavior, the vagaries of life, the impediments beyond the conceivable thought, and above all, prevention from taking steps to stop. The appellate court should be slow and circumspect in this regard, and a discretion is to be exercised by the court on the basis of the facts pleaded by the parties, and such discretion should be exercised judiciously as opposed to capricious and arbitrary exercise of such power. The appellate court should should slow and circumspect in interfering with the discretionary order unless the court finds that such discretion is exercised unreasonably, irrationally, and contrary to the statutory provisions applicable in this regard. The appellate court should not interfere with the order even if it found that the other view is possible when the view expressed by the trial court cannot be said to be unreasonable. Full stop. Both the courts have found that the plaintiff, the appellant have miserably failed to prove the case made out under Section 5 of the Limitation Act as well as under Order 9, Rule 13 of the Code of Civil Procedure, and have simply founded the aforesaid applications on the ground of the age and sufferance from various disease. The pleading is not a substitute of proof. A party has to prove the pleadings by a cogent evidence, which in the instant case does not appear to have been discharged by the appellant. After the ex parte decree was passed, an attempt under Section 47 of the Code of Civil Procedure was resorted to, which ended in a dismissal. And thereafter, the recourse under Order 9, Rule 13 of the Code of Civil Procedure is taking a circuitous route to achieve the same goal, which in our opinion should not be encouraged. From whatever angle we look at, both on merit as well as the interference with the discretionary order, we do not find there is any involvement of a substantial question of law. The appeal is thus dismissed. No order is to cause.
Well, my lord, I appear for the plaintiff petitioner, my lord. Now, what had happened, my lord, for the past 1.5 months, my advocate on record could not contact the client, my lord. Now, what I am, my lord, today praying, subject to convenience of your lordships, if your lordship can kindly keep it on Friday, we'll make a final try to contact him, my lord. But this is, we are before.
What are you talking about? On
July, my
20th
lord.
July,
After that, my lord,
he says that the talk of settlement is going on.
after that, my lord, they could not contact him, my lord. No further instruction has come. Now, we
That
are,
means the settlement has been arrived. So
I don't know.
don't. Obviously, they do not want to pursue the matter. Maybe.
I don't have that instruction, my lord. We are against, before your lordship, against refusal of an ad interim injunction by the court below in a suit of for partition, my lord.
What kind of injunction?
My lord, we had prayed for main injunction was
Alienating.
Yes.
What are you talking? Can it be granted?
Or at least order of
Can
status
it
quo,
be?
status quo could have.
You are a co-sharer.
Yes.
If you have a right to alienate and thereafter you will prevent the other co-owners to not to sell. What are you talking about?
But an order of status quo could have been given.
Why status quo? Most ambiguous order. No status quo should be granted in this regard. Have you seen my judgment in this? I have said you can't injunct any other co-sharer from dealing with the property. Now in a Supreme Court in 2024, Volume 7 SSC has also held so. Says you cannot prevent the other co-sharer to alienate the property. Cannot. They have equal right. They are the co-owner. Under the Transfer of Property Act, there is no bar. Why Section 44 of the Transfer of Property Act was enacted? In respect of a dwelling house? That if the co-sharer has already sold his share, then he is not entitled to a joint possession. That means there is no bar in selling his share. Only thing is a joint possession. An injunction. No. Gone. We are simply dismissing him for default, nothing more than that. What can be done? Or you want to attempt?
No, my lord has expressed my lord's mind.
Can't be. Can't be. I'm not in. Subject to my brother's concurrence.
He appeared dismissed for default.
No.
My lord,
He's not appearing.
kindly keeps
You're
it on
not
Friday.
appearing.
I am appearing.
Friday has to be mentioned.
Yeah. Great.
Yes, call the next.
I'm for the appellant. Go to the virtual mode. But against the order of remand, I'm for the defendant appellant. But the trial court's order judgment has not been imposed with this appeal. It's against the order of remand. All these are my lord.
A certified copy of the judgment and decree of the trial court has not been filed.
Yes, that is not filed. But just yesterday, I got the papers that I find that judgment has not been. That is
Then what to do? Then we are dismissing it for non-compliance of this order.
No,
The defect as pointed out by the stamp reporter, if not removed within 2 weeks from the day the appeal shall stand dismissed.
Okay. Good.
Yes, call the next. 14. What is this?
Lord, as a matter of right, I appear for the appellant.
Yes, should. We appreciate.
So, Milord, yesterday, Milord was considering, Milord, the section 5 application, Milord, which we had referred. Milord, this is against, Milord, rejection of the order 213.
Have you seen 2 judgments of the Apex Court recently of the Supreme Court delivered by Justice Pankaj Mittal?
No, Milord. Sorry, Milord.
And then a very recent judgment of 24th of August 2024, another 3-judge bench presided over by Justice Surikant on Section 5. I have narrated those which transpires from these judgments.
Three judges.
dichotomy between section 3 and section 5, Justice Mittal has elaborately discussed. So you tell me whether you come within section in that parameter.
May I consider that and come back tomorrow then?
These are the two latest judgments I am giving, one of a division bench, another of a 3-judge bench.
I will, I'll consider it.
Your Lordship, I am for the respondent number 1. In this matter, I am led by Mr. Arun Kumar Sarkar. He is appearing virtually.
Yes.
I'll just go and.
Your Lordships, Mr. Sarkar will be leaving for Hyderabad for a wife's medical treatment. Your Lordship. Then
So do it today. What is your case? I will tell you what the principles are. Tell me, what is the matter about?
My lord,
He is available today. He can argue. No difficulty.
my lord, I am on the video line, my lord. Can you hear me, my lord?
Yes.
I can see you and hear you both.
Oh, okay, my lord.
Yes.
Okay, my lord.
Yes, argue the appellant.
My lord, you have seen the petition for continuation of delay.
Let us see. Are you not opposing?
Actually, my lord, everyone knows that there is no
No,
sufficient.
tell me one. Are you opposing section 5 or not opposing?
Let it be allowed, my lord.
Let
I
it.
leave it to the landed court.
Then we are allowing it on that.
Good.
I leave it to the landed court.
Yeah. No, you have said you have allowed. Don't leave it to us. We will record that. Yes.
The ground
This is an
has
application. This is an
That might
application
be
for
lawyer.
continuation of delay of
181 days.
181
days, my
days
lord.
in
181
preferring
days,
the
my lord.
instant appeal.
Yes.
Full stop. After hearing after perusal of upon perusal of the amendments made in the said application, it is submitted by the counsel for the respondent that he does not have any objection to the condonation, provided the appeal itself is decided within a short period of time.
Yes, my lord. This
In
is my
such
only
view of-
submission.
This is in such view of the matter, the application for condonation of delay is allowed on consent. When you are ready, tell me, we will fix the matter, appeal itself.
Next circuit, my lord. Any day in next circuit.
Next circuit,
But in the Miller, I'll just pray for a limited protection, not to dispose.
what limited protection?
Not to dispose. Miller, because not to dispose.
No,
Because
has it been dismissed or allowed?
Miller, it has been, Miller, my order 9 rule 13 has been dismissed. Miller, there is a suit for Miller eviction. So the decree is there and they have already preferred an execution proceeding. And if Miller
What
takes,
is the stage of the execution?
Miller, they have preferred it. Miller, the Nazir has visited the premises.
The objection has been registered.
Miller, I am not aware of that. Miller, Mr.
Order 21 rule 1997
Mr.
filed or not? Application under order 21 rule 97 is filed or not?
Mr. Sarkar.
Mr. Sarkar,
Yes, they have filed it.
they have filed or you will file?
He will.
No, we have filed the execution case, my lord.
No. Application under order 21 rule 97, have you filed?
No, my lord.
So you will get a lot of chance.
Kindly see, Miller, in the first order, Miller, this bench has granted me a limited protection only to that extent. So
How
they
can
won't-
it be? I have
now Miller has.
I have lot of,
Miller, 41.3 and Miller, yesterday we had considered.
that is what I'm saying, 41(3)(a)(3) says unless the condonation is done, you
Miller,
can't. But
it's
now,
condemned. Miller is
now
now condemned, Miller,
admission.
only to the limited extent.
admission,
Miller, kindly hears that out, Miller.
it's an admission has to be done.
Miller, kindly hears that out, Miller. Mr. Sarkar is the
2017 volume 6 SCC is against you, which I have, that the court should not pass any interim order unless the court admits the appeal.
That's right, Miller. There's no quarrel with that proposition. Miller, I have made out an arguable case. If Miller kindly hears me for 5 minutes. I have made out an arguable case.
As a tenant,
No,
suffering
not a tenant. Miller, I am a wife who is married. It's my husband's house. Husband is one of the co-sharer. Domestic Violence Act 498 proceedings are pending. My case is this decree has been obtained entirely, Miller, surreptitiously.
If you takes the pleadings of my ordinary rule 13 application, would find there is a foul play on the face of it.
Next circuit.
Next circuit, fixes up a date on the
Yes,
first day of the next
the-
circuit. Kindly protect me to some extent.
Yes, my lord.
The appeal is admitted.
Grateful, my lord.
The interim order passed earlier is extended for a period of 3 weeks from date.
Grateful, my lord.
It is however made clear that all formalities, including the preparation of paper book, are dispensed with.
Grateful.
Let the appeal and the application be listed in the
My lord,
next circuit. Will start from there. We can indicate the date. Mr. Sultan,
Lord, I'll just
will indicate the date on that day. It will.
Lord, I'll hand over.
What are you lordship?
What is the next? When it starts?
My lord, after one.
After
this-
13, tell me when. I think that week 13 week will be over. 23rd.
September.
So let it be listed on 23rd.
Grateful.
Obliged, your
23rd will
lordship.
do, Mr. Sarkar?
Yes, yes, your lordship.
Yes, 23rd.
Great.
Pause.
5 minutes. दो देखिए
কালকে এক্সপ্লেন্ড
डिग्री पत्नी
injunction.
of title. Oh, problem is a reversal. Positivity effect for example, the competition to be very তখন পুরো রাইটটা ওখান থেকে চলে যায় তবুও এরা আসছে না তাই বুঝে পাই না not today. Who is this Riya Agarwal? Anybody knows? And Mr. Kaushik Kumar Kanu? Why she is not appearing? And this is the suit relating to a declaration of title. And if we dismiss it for default, they do not know the consequences because it will affect not only the parties but also the generations. They will be deprived of the property.
Another thing that she's appearing in other courts but are not appearing.
Then this is what then we'll have to dismiss it. Pass over, tell her to come.
Yesterday also it appeared.
I am for the state.
The PP has been appointed or
Yes, Lordship, this is the notification.
এটার জন্য বোধ কিছু
The notification dated 27 June 2023.
Record has gone.
Yes, record has already gone.
Wow. How many witnesses have been examined?
No,
What copy?
207, 207.
207.
Why?
Charge sheet was filed before the court on 4/9/2023.
What was recovered from him?
Roughly 720 spasmo vaccine.
Is spasmoproximon.
Contraband.
It is now a contraband.
No.
Yes, it is contraband.
Now a contraband.
Now a contraband.
It was not at one point of time.
But in relation to Catholic for 18 months, Russian there was a direction by coordinate bench to complete the trial within 6 months. That is September.
Right. The petitioner is in custody for
18 months.
18 months.
for nearly 18 months in connection with the aforementioned case.
Charge sheet was filed when?
Post hoc.
Lordship charge.
The charge sheet has already been submitted on
4th September
4th September
2023.
2023.
He was not served.
But till date, the copy as well as the relevant documents have not been served upon the petitioner. So it further transpires that the instant case has been transferred to a subdivision, but no progress could be seen because of
One in this lordship.
non-appointment of the special public prosecutor.
Alipurduar is now a new district.
Has been transferred to another district after bifurcation. Stop. The state informs that the special public prosecutor has been appointed on 27/6/2023. The record would reveal that there are 17 witnesses, charge-sheeted witnesses. But the trial has not commenced as yet. We do not find any possibility of a trial to commence or concluded in near future?
Lordship, state raised objection.
Even though the state has raised an objection to the instant application, but we find that a person should not be incarcerated for all time to come because of a delay in commencement of a trial. First off, we therefore allow an application for bail, 10,000, attend the case regularly, one default, cancellation without any reference to this point.
Lordship, one condition, not to leave the jurisdiction of the court without a leave.
Yes, with conditions that he will not leave the jurisdiction of the court without taking a leave from the concerned special court.
Much obliged.
Special court under NDPS Act.
You tell us, which court?
NDPS court, Alipurduar.
Satisfaction of the NDPS court, Alipurduar. Yes, call the next.
There is no chance of.
79 for the state, your lordship.
Which for the other side?
Papai Muhammad.
It's not here.
Who is
NDPS case, your lordships. Previous rejection.
Reason is not here. Oh,
Previous rejection is there. That's why they didn't turn up.
antecedents are there?
Antecedent, your lordships, they are the from his positions, contraband has been seized, your lordships. And earlier occasions also considered by your predecessor that his involvement is direct involvement. So that's why they didn't turn up.
Dismiss it for default?
Can, your lordships. Otherwise, it will be.
None appears in support of the application.
dismiss.
Dismiss. Yeah. And for the statement.
Dismissed her, so. Earlier rejected.
Yes, my lord, in the month of August, my lord, 2nd August.
What is his name?
Dismiss.
লিখে দিতে হবে এক লাইন appear করেনি
জানে none appears in support of the petition, জানে call the next.
Lordship, I'm for the petition. Lordship, I'm renewing my application. That's because
When it was earlier dismissed,
Lordship.
23rd of July.
Lordship.
Yes.
Liberty was granted concurrently. Lordship sees
Yes.
page 9.
What is the issue pending before the larger bench?
Lordship, filing of charge sheet without the FSL report. Lordship knows.
Now the Supreme Court has Justice Padiwala's recent judgment is there. It says that you can't do it in this fashion.
Lordship.
Where is that judgment of Justice Padiwala?
Lordship, I just got the CD, I did need, I paid for 1 day accommodation.
What accommodation?
I'll just go through the judgments and come back. I just got the CD just now.
To curtail my right of indefeasible right, which incomplete charge has been filed. Now, Lordship knows that better than us that in Ritu Chavaria's case, Honorable Appeals Court released the accused on bail. But subsequently, the Union of India moved an application before the Honorable Appeals Court to prevent the same. But we have all the judgments there, where Honorable Appeals Court kept this matter under consideration, but bails were granted to the accused person because, and in our case also, Lordship only sees the order. Last paragraph, paragraph 5 and 6, page 10, Lordship.
Is a premature.
Yes, because the time was given, para 5, Lordship.
Have you got the FSL report?
No, Lordship, that is the thing.
Just now I got the CD, Lordship. I was just going to the.
Tomorrow.
Yes, Lordship.
I'm for the petition, my lord. I'm for the petition.
Is the sixth application.
This is my lord.
Yes.
We are on
reply.
that is not ready because they have relied upon certain documents regarding their qualification which was granted under
Why
we have
you
said
will not-
we have sent the documents for verification to UEC
No, who are you?
I am the applicant.
A district inspector of school, what for? Then how long the court will wait for you?
Lordship, because that certificates are too.
No, this cannot be done.
Lordship,
How long? This was done on 12th of August. Now we are again heading
we have
towards
already
12th of September.
the applicant has sent the documents.
What's in the document?
Sent
Then
document for
how many-
verification.
How much time you require to get a verification?
They have not yet replied, so
Sorry, we can't. Then we'll have to pass an order.
Lordship, 1 week,
No 1 week.
we have sent it to.
On the prayer of the appellant, time to file appellant reply is extended by a week from date. This is the matter on the next Wednesday.
Grateful.
Call the next.
After the writ petition, I responded in the first appeal and the appellate in the second appeal led by Mr. Shopsanshu Basumala. He is appearing virtually.
First step, my lord, I am the appellant. So the first appeal is the state circle, that's our appeal, my lord. The second appeal is of the writ petition.
What is the order? We want to look at the order.
may I
What is
just-
the nature of the order?
Yes, my lord, before my lord goes to the order, my lord, the third appeal of the SGD is not served to the state, my lord, we need a.
No, this is going on for 4 circuits.
No, we have
4
not- we
circuits,
have
they are
not-
sought for time. I have the orders, my lord. 4 circuits, they are sought for time and it has gone to next
The last
circuit.
location of the
They let them move it today or tomorrow. I'll wait, my lord.
No,
Let
we'll
them
do it in the
move it
next circuit,
tomorrow.
sir.
Yes, yes.
We'll do it in the
Tomorrow.
next
Let's do it tomorrow, my lord.
Let
4
us see
circuits they
what
have
is the
sought.
order? What is the
My lord,
matter?
what happened, my lord? A proceeding, land acquisition proceeding under Act 2 initiated. Section 3, Section 4(1)(a), it lapsed, my lord, under Section 7, capital A. It was, award was not declared within 3 years, my lord.
Then
As per the
they-
special bench.
Whether they took any.
No,
under section
9A.
9A.
No. That was
of
not
the
done.
Act-
Award was declared, but beyond 3 years. Beyond 3 years. Award was declared beyond 3 years. So, my lord, the proceeding has lapsed. Honorable single judge has held that yes, the proceeding has lapsed. There were 2 plot numbers. One has been directed to be returned to us. The other, since a ad hoc payment was made, the court has said that you cannot get back that land. So our appeal is only in respect of that plot of land. We say that at least we should get the compensation because it was only ad hoc. It was not completed, no valid award was passed. This is our appeal. Their appeal is not challenging the order, which they declared the order as declared the acquisition as lapsed. They have challenged that.
Acquisition was done. Was there any rent compensation awarded?
Rent compensation, honorable, no. Honorable single judge has awarded the rent compensation in his judgment.
To be calculated.
To be calculated in respect of one plot.
When the land was requisitioned.
Requisition in 1990. 5th May 1990.
That act lapse, when it expires its life when?
Expired 31st of March 1997. The act expired, my lord.
That's no, I know, I'm conscious.
And there was the 1996 amendment which brought in section 7 capital.
Correct, I know.
So it was to be within 1 year from the date of that amendment. That was not done. Beyond that, award was declared. This is a special bench judgment of Shobita
Amendment under
Mundra.
section 9 of the Act 1 came.
No, they have not. Yes, Act 1, 9C and 9CB came.
There was a fresh lease of life which was given to the state. It did not serve a notice.
No notice, and in this case it cannot be because only the notices which survived on the date of expiry of the act, only those could have been revived. But they have not revived it in any case.
There are 2 or 3 in it remained under requisition, then they can.
It didn't remain, they passed the award, but that was not beyond the time. So the award lapsed. There was no attempt to revalidate under 9 CR, 9 CB, and the 13 Act has come into force. This is the
What to
position.
do? My own judgment is staring at your face.
More than
If this can be taken up.
My own judgment is staring at your face. Tell me that I am wrong in my judgment. I am ready to accept.
I am led by the additional advocate.
Sorry, we can't.
Yes, that is there. Let me next week, we'll
No, no, there's definitely bad judge for that. Everybody who is frequently appearing before me, he knows that I am a very bad judge for that.
No, definitely not, my lord.
If you have come, you have to argue the matter, nothing more than that.
We do not even have the copy of the SGDS app.
Sorry, that we can't. If you don't have a copy, that's your misfortune. You'll have to argue. This cannot continue. And when they say that this is happening, the same thing is happening since last many circuits, I'm the last person to disbelieve that.
May I just say this one?
Next week.
Nothing, you'll have to argue now or.
Well, kindly take step tomorrow, Mother. Kindly, Mother.
No,
Only one day, Mother.
No, no, no. No, Mr. GP, sorry.
The problem is, Mother, I don't have my brief today, Mother. That is the problem. I'll be very candid.
Why you have not, then your office is, I think all the officials in your office is incompetent.
In this matter, Mr. Roy, he's for SDG lordship.
SCDM, Mother. That is fine.
Very good.
So requiring body, what he has to say, acquiring body will say what should be the quantum? Only thing is that he has to pay the money, nothing more than that.
Here is
What
the
acquiring
case,
body
Mother.
will do? No. Nothing. Not judgment.
All the judgments have been considered. So from
Justice
Will
Tender.
see my judgment.
We'll go through the.
We'll go through the judgment. That,
I'm giving a copy to him. Let him.
no.
I'm handing over a copy to my lawyer.
I had an occasion to analyze the effect of both Act 2 and Act 1.
When it can be revived by 9C and 9C.
So tell me if my judgment, if I am wrong in my view, then I am ready to correct myself. I have no ego or the vanity in this regard. I am still open. Nothing.
We'll do it in this second. Day after what?
Here, Mother, we have reached the corner, Mother. Your Lordship, kindly take step tomorrow.
Then come tomorrow. I can give you only a time till tomorrow. Come and argue.
I cannot go. I'll argue online, Mother. If your Lordship promise you that.
No, that is, we always permit somebody to appear virtually.
Mother, I will definitely, Mother, assist your Lordship.
If my lord
Tomorrow.
If my lord is fixed
2
tomorrow,
PM.
yes, 2 PM. I want to come
very grateful.
physically to disturb my lord.
Tomorrow.
Very grateful, Mother. Very grateful.
I will come physically.
Run for the appellants.
And for the private respondent, your lordship, I'm led by Mr. Shayan Chattopadhyay, your lordship. He has his legs before principal bench, your lordship. If you could, lordship, give me 1 day accommodation.
He will not be able to come back today.
Your lordship is moving a matter before the principal bench. That's why he was there. He was
Who?
Mr. Shayan Chattopadhyay, your lordship.
His name does not appear on the last occasion.
Yes, your lordship. Last time he was not served, and we accepted the service on his behalf, and we have duly served him, and he will appear in this matter, your lordship.
What is the matter about? Section 5 allowed or not?
Well, Section 5 is
Section 5
allowed. Section 5 has been allowed. Today is
Allowed.
fixed for hearing of the
So,
stay
so
application.
what is
The impugned order, my lord, would find at page
what
30.
is the matter about?
But this matter pertains to recruitment of ICDS employees, means Anganwadi workers and Anganwadi helpers under
Yes.
the ICDS scheme. But would find the impugned order at page 30 of the stay application.
Only one day, Your Lordship. He was there, he wanted to move the matter, but then.
Tomorrow,
Yes, Your
tomorrow,
Lordship.
tomorrow.
Grateful, Your Lordship, without
Tomorrow.
any delay.
Tomorrow 2 p.m. Next.
Lordship, I have just now received the brief, Lordship. 2 to 9. Lordship, can you fix it?
Yesterday, when we had a meeting with the bar, everybody's grievance was that the writ petitions or the appeals, civil appeals are not being taken up. So we decided that one half will be kept for those matters and one half for the bail. But look at the plight that nobody is ready to do the matter.
Lordship, can you
This
fix
is
this
what,
on Monday,
this is
Lordship? I
not,
will
you
do it.
wanted, you have a grievance, but you will not justify that grievance.
So this is change. That's why.
Why you are accepting a change brief?
And just now, Lordship, at 2, I have received.
Why, then why you accepted it? When you knew that you cannot appear, you cannot do the case. Why you accepted the change brief? And so far as the High Court is concerned, it never encourages this kind of a adjournment. Why you accepted it? It is a grievance. What is the grievance in the writ petition?
Primarily with respect to the percentage of the share that is.
How the writ lies? How the writ lies? How writ lies? That may be a civil dispute. Why? I was really wondering that why the single bench has gone and correctly decided. We can't say that on merit there is any difficulty. If your father has a 33% means 1/3 share and left behind him surviving the 4 heirs, one of whom relinquished, says, I do not want to inherit, then relinquishment must be in favor of the surviving others heirs. So 33, she said 11% you are entitled as one of the heirs. What is the wrong? Practically, there is no wrong in the judgment, but wrong in the exercise of jurisdiction. How the writ lies? Is a private dispute. So, writ. Where is the writ petition? Where is the prayer in the writ petition? Let us see. Oh, this is under the Excise Act.
Yes.
Oh, then there may be something because the excise peoples, they wanted everything to be done. Anyhow, but on merit also we do not find. We do not find. No, no, that joint licensee having how much share?
That is the 1/3 share, 3%. And out of that 1/3 share.
So the name of the another,
Entire 1/3.
just name of the entire, sorry, the other heir who has relinquished is also incorporated.
But the person who has already relinquished, that one really leaving only 33% share, that share has been distributed among the legal heirs of that person.
Probably you could not get what I'm saying.
Yes,
One Trikam Ram or Tikam Chand, whatever, he was having a 33%, 1/3 share.
1/3 share.
He left behind 4 years,
4.
out of which 1 year relinquished.
Yes, yes.
So only 3 years.
Yes, 3.
I am asking you a very simple question, whether you have recorded when I recorded the name of all 4 years or 3 years.
No, only 3 years. No. Only 3 years to the extent of 11% each. That total.
That is what you have said. That's why I wanted all the name of 4 or 3.
3.
3. So no difficulty. Where is the problem?
11% each.
Where is the problem? No, nothing. Nothing.
Lordship, kindly, Lordship, want.
What for? You are really postponing the death. It will be the same thing tomorrow. No. The dispute pertains to What is the matter about?
In this case, Lordship, the Honorable Single just passed an order for regularization of contractual teachers.
What?
They are, the read petitioner was a contractual assistant teacher, Lordship.
What? What is this internal red tapeism? The learned judge has recorded in the order dated 30th July. Delay. No, election by internal red tapeism. Why is this? What's the reason for delay? Yes. What is what the trial court has held?
Lordship, by paragraph number 1 of appeal, Lordship, the trial court directed to approve the appointment of the respondent if the respondent fulfill all the requisite criteria to be appointed as the post desired by the respondents, Lordship.
What is your
Contractual assistant teacher, Lordship.
correct? Then
But
appointed when? Appointed when?
Lordship.
Already 3 page. अच्छा इतना state of the secretary state of Karnataka.
2009, Lordship. 21st December 2009, Lordship.
What?
I am
You asked for?
for Gorkhaland Territorial Administration.
What they asked for?
Regularization of their service, Lordship.
Services. Is there any sanction post?
Lordship, Lordship, because we have filed this appeal because we have no jurisdiction to appoint the writ petitioners, Lordship, because Gorkhaland Territorial Administration has no role.
Who appointed them contractually?
States, they are the voluntary teachers, Lordship. On
I'm
voluntary
asking
basis,
you
they have
who appointed them contractually?
the school authority, Lordship, managing committee.
Under what law?
Lordship, because in the Hill region, there is, at that point of time, there is no school service commission and school has to run. That's why the managing committee appointed them, Lordship.
No, there must be a source of power. One cannot, or in the one fine mornings, assume the power and think that I have power and then do it. There must be something there. Any rule, any kind of regulations, anything that
Lordship,
was
there
there.
is no such rules, Lordship.
Is then the managing committee thought
Yes.
is it a private school or a government school?
Government aided school, Lordship.
Yes.
Government aided school, Lordship.
If the aid was being given,
IT government, Lordship.
then there is a management rules also. Regarding
Lordship,
to the
that's
government.
why we do that direction upon the GTA to regularize their service. But school commission, school service commission has categorically stated that without the concurrence of the state government, we cannot regularize their service, Lordship. Kindly see Annexure C, Lordship.
Who is for the writ petitioner?
Sir, Ikramul Badi, sir.
You are for the writ petitioner?
No, he is for.
Mister? Where is he?
Not similar, Lordship. They are non-teaching staff, Lordship. They,
What has been done?
in those read petition, state has
No,
taken.
is a transfer of the administration. What are the powers which is given on the GTA?
Lordship, kindly see Annexure C, Lordship.
The transfer of territory and the administration.
Local and state liability, Act 2011, has given industry free entire power to GT, including the appointment of.
The administrative and financial.
Where is that?
Page 47, kindly looks, page 47, Lordship. This notification was issued by the government of the West Bengal on 1st October 2012, Lordship.
True.
And the next page, Lordship, 48, page number, paragraph number G, Lordship.
Just executive power.
Paragraph G is relevant, Lordship. The existing vacant government post in the office of an institution.
Just 1 minute. Let us see under a schedule what it comes. Yes, 3, what do you want to say?
Yes, paragraph number G, Lordship.
Yes.
Existing vacant government post in the office and the institution so transferred under Schedule B above shall not be filled up without the concurrence of the state government. Now,
Where is the Schedule B?
Just open.
Schedule B. Yes. You are not coming under the Schedule B, you are coming under Schedule A, Roman 7. It's a aided school. And there are 2 government schools which have been kept outside. They have been kept outside in Schedule B. One is what is this, Victoria Boys School, and the one is the Downhill Girls School.
no, all government primary school and higher secondary in the same region.
No,
All schools.
it says that all government.
Yes.
I am talking about 7, sir, madam. All non-government state. You are a non-government because the school is a non-government school institution, but getting an aided or a state sponsored or unaided recognized primary schools and such will come under you. Schedule A. So naturally the service and all everything is relatable to this. That will also come under you. B is the appointment of a district inspector of school. All these, the concurrence of the state government is required.
Para 4, Lordship, in Schedule
Please.
B. All government pre-primary, junior, high school.
Where is the paragraph 4?
Schedule B.
Column number 4, Lordship.
Yes.
All government pre-primary, junior, high school and the high secondary school. In the
Madam, it is not a government school. You say management of the school means it is a private school getting an aid from the government. Either is a DA getting a school or something. You say it's an aided school. Aided means that government financed the school to run, but it is the managing committee who is independent. That is what I understand when you use the word aided school. I do not know what is the concept of what this school is. Is a pure government school or it is what? That's why I wanted.
Instruction, this school are
Aided school.
Falls under the Schedule B, Lordship.
That will not instruction. You'll have to ask that what is the nature of this. You said that is a aided school. Where is your stand in the writ?
What is the name of your school? What is the name of your school?
It's not Victoria nor Downhill.
Yes.
I just wanted to know where is your stand in before the writ?
No, writ was filed by the respondent.
But you
lordship.
must have responded by filing opposition.
No, we have not filed. State has filed, lordship.
So the what state says? State says is the aided school. Where is that order?
Kindly see the annexure D, lordship. Page 51.
Annexure D.
D, page 51, lordship.
Yes.
Yes, lordship. Last paragraph with reference to your memo dated so and so, dated 21st July 2023. This is to inform that none of the petitioner were engaged with approval from this end. Or also the undersigned, thus no authority is given approved of appointment. So question of the
True. That is why I say that it does not come under B. So my concurrence is not required. It comes under A. So you are the authority who can give
has
a.
to come from the state lordship.
What?
Who will
I
give
do not
the
know. When
salary
there was a
lordship?
transfer, whether the state government has ratified to give a particular fund, we don't know. That you can't. This notification has come. That's why I was just thinking that how the stand has been taken. What is the stand of the DI? DI you are representing. Oh, you are representing DI.
It was actually not party directly.
Sorry? Then how you are made a party here? Whom you are representing, sir? Sorry?
You open your brief now.
So, so you are representing the school. No, I am talking about in the appeal, sir. Which respondent? So you are representing. Why? Then why they are made a party? They were party.
Commissioner of school was not made party also.
Yes, lordship, they were party. Yes, lordship. Respondent number 5, lordship.
Then commissioner of school. Whatever commissioner of school is made was party. Not a party. In the petition. Not a party.
No, school service commission was in my appeal, lordship.
But
annexure
in
number
the appeal, they have been made a party. That's all. That's true.
The same party as was there in the.
Yes, that should be.
Lordship, in my appeal, lordship, I have annexed the Chandan Kumar Singh case, lordship. In that case, the Honorable Justice Abhijit Gangotpaধ্যায়, that the Department of Education, Government of West Bengal, without his making him party, this writ petition is not maintainable. Lordship, annexure number E, page 52. Or they have not made School Service Commission as a party respondent, lordship.
Why is Mr.
Page
Party?
52, lordship. Chandan Kumar Singh ordered, lordship.
What for?
In this case, the Honorable Judge directed Department of
Is it-
Education, Government of West Bengal.
Is it binding on a division bench?
No, lordship.
So
But
Why
Lordship,
you are referring a judge, the order of the single bench, the division bench may differ. May not agree on that. We are not bound by the single bench judgment. I was just thinking that what authority you acquire or you have under those notifications. I'm still unable to understand whether it is a government school or a government aided school or a DA getting a school.
Take instruction.
then Lordship, 1 day accommodation, I'll take instruction, Lordship, in this particular point, Lordship.
And second question is, even if it is the government, under what authority the regularization can be done?
As per the DA,
No, I understand, but under what authority the regularization can be done? It is not a sanction post by the GTA, then where is the writ petitioner? Have you served?
Yes, Lordship, Kramul Bari sir called me during the break hours that he requested me to take time.
No, it's kind of naughty because he's in habit of taking time.
and you proceeded and submitted your argument submission.
Tell him to appear tomorrow.
Any.
Grateful, Lordship.
Call the next.
You.
Let's call the next.
In person. Who is for the state or something? Who is for the state? You.
Yes. কেন পাঠিয়েছে?
Security. Your father is a security.
Yes, ma'am.
Why your father? He's a lawyer. Then why you are representing your father?
My Lordship, actually, my
Have you got the authority from your father who is there?
special power of attorney, my Lordship, to
Yes.
execute.
So why can't you? Are you an advocate? No, I'm asking you. Are you an advocate? So you can represent and answer all the question of law?
No, my Lordship, but
So-
this petition filed by me with
Not by, it is by your father.
yes, my Lordship.
Yes.
Yeah. Lordship, can I submit in Bengali, my Lordship?
Sure.
My Lordship, actually আমার বাবা অনেক দীর্ঘদিন যাবতই প্র্যাকটিস করেন না আর বাবার শারীরিক অবস্থা ভালো না বলে আমি বাবার কনসালটেশন নিয়ে এই ফাইলটা আমি আর বাবা মিলে করেছি, বাবাই ফাইল করেছে অ্যাকচুয়ালি, বাট ড্রাফটিং এন্ড অল দিস
আপনি করেছেন?
ডান বাই
দেন কি গ্রিভান্সটা কি?
মাই লর্ডশিপ অন গত বেঞ্চে এটার রিপোর্টস যে পাঠিয়েছিলেন এই কোর্ট ফরেন্সিক ডিপার্টমেন্ট থেকে, সেই রিপোর্টের জন্য আজকে এখানে।
না, আপনি যখন সিঙ্গেল বেঞ্চে গেছেন
Yes, ma'am.
কি জন্য গেলেন?
মাই লর্ডশিপ অ্যাকচুয়ালি আমার বাবার কিছু প্রপার্টি নিয়ে ডিসপুটস হয়েছিল, সেটা নিয়ে আমি একটা রিট করেছিলাম, আমার বাবা করেছিল অ্যাকচুয়ালি হাইকোর্টে, পুলিশ ইন অ্যাকশন ইন দি রিট কোর্ট। তো সেখানে অর্ডার হয়েছিল এফআইআর রেজিস্টার করার জন্য, আর স্টেট রেসপন্ডেন্ট দ্যাট ইজ পুলিশ অথরিটিস ওনারা স্ট্রিক্টলি সেই একটা বাবার তরফে একটা ডিগ্রি হয়েছিল, সেই অর্ডারটাকে স্ট্রিক্টলি মান্য করবেন বলে একটা অর্ডার হয়েছিল। তো মাই লর্ডশিপ এখান থেকে আমি আলিপুরদুয়ারের বাসী। ওখানে যাওয়ার পর আলিপুরদুয়ার কোর্টে আমি আর বাবা চেক করতে গিয়েছিলাম যে সেই এফআইআরটা রেজিস্টার হয়েছে কিনা আর কি নাম্বারে হয়েছে। তখন সেখান থেকে আমার বাবা জানতে পারেন যে বাবার নামে অনেক দিন যাবতই এরকম সিগনেচার্স হচ্ছে। তো দ্যাট ইজ দ্য ইনফরমেশন অনলি মাই লর্ডশিপ। সেই সেই হিসাবে আমি সার্চিং করার পর অনলাইনে একটা মামলা দেখেছি যেটা বাবার নামে মানে হয়েছে, that accused has been অ্যাকিউজ পালিয়ে গেছে, তার জন্য বাবাকে যে সমন করে যে মানে একটা প্রসিডিং চালায়, সে একটা কেস আমি
440
ইয়েস ম্যাম,
of CRPC.
সেটা আমি দেখতে পাই অনলাইনে। কিন্তু সেই কেসটা হয়েছে 2017-এ। টিল নাও আফটার নাও সেইটার নোটিশ যে জারি, আমি সার্টিফাইড কপি উঠিয়েছি, ওটা নিয়ে আমি রিট কোর্টে এসেছিলাম যে এটা হচ্ছে, এটা অ্যাকচুয়ালি ট্রু, নট বাই অনলি ইনফরমেশন।
সেখানে আপনি কি বললেন যে আপনার ওখানে যে সিকিউরিটি হিসাবে যে বাবা ওখানে দাঁড়িয়েছিলেন, সেটা কি ফলস, ফ্যাব্রিকেটেড নাকি জাল, কি সিগনেচার, সেটার জন্য কোর্ট কি অর্ডার করেছিল?
অ্যাকচুয়ালি মাই লর্ডশিপ ওটা করার পর আমি বার অ্যাসোসিয়েশন, পুলিশ স্টেশন, সিজিএম আলিপুরদুয়ার আর ডিস্ট্রিক্ট জাজের কাছে একটা চিঠি করেছিল আমার বাবা, যে এমন তো আমি দীর্ঘদিন যাবত প্র্যাকটিস করছি না, ইভেন আমার লাইফে কোনোদিন আমি কোনো বেল সিওরিটি করাইনি।
না, আপনার সিওরিটি সিটটা তো মানে সারেন্ডার করা উচিত ছিল প্রথমেই, যখন এতদিন কাজ করছেন না, সিওরিটি সিট তো সারেন্ডার করতে হবে সিজিএম অথবা ডিস্ট্রিক্টের কাছে, যে আমি কাজ করছি না, আমি আর কাজ করছি না। সেটা করেননি কেন? Is there any document that you have surrendered your COT SIP asking the concern? Then
স্যার নো মাই লর্ডশিপ, তবে এটা ধারণার বাইরে ছিল যে এটা আবার ফোর্জারি করেও চালানো যেতে পারে।
কিসের ফোর্জারি? COT
রিপোর্টটা এসছে?
হ্যাঁ, দ্যাট ফরেন্সিক আই ওয়ান্ট ইন দিস অ্যাপিল।
সেটা রিপোর্ট এসছে?
আই ডোন্ট নো মাই লর্ডশিপ দ্যাট
এটা এসছে তো এখানে, এই রিপোর্ট এস কাম।
আপনার অ্যাডমিটেড সিগনেচার নেওয়া হয়েছিল?
ইয়েস, 2 times মাই লর্ডশিপ।
এটা রিপোর্ট এসছে,
হ্যাঁ, খুলুন না।
খুলুন।
মাই লর্ডশিপ যখন রেজিস্টার খাতা বাবার নামে আমি চেক করতে গিয়েছি, বাবাও দেখেছেন প্রচুর হয়েছে, and that none of my father has been done.
বাবা কি করছিলেন এতদিন?
বিজনেস মাই লর্ডশিপ, ইন পার্টনারশিপ বিজনেস।
বিজনেস সিওরিটি সিপ সবকিছু চলবে একসঙ্গে? আপনি সিওরিটি সিপের যখন করছেন না তখন সারেন্ডার করে দেওয়া উচিত ছিল তো, সেটা তো আপনার জানা উচিত ছিল। দেখা যাক রিপোর্ট কি এসছে, দেখা যাক। আপনারা তো সব ডিস্ট্রিক্ট কোর্টেও যান তাই তো নাকি? ডিস্ট্রিক্ট কোর্টেও তো যান আপনারা, ইউ ইউজ টু ভিজিট। You have any idea about COTC? Nothing. So you're a civil lawyer. No? Criminal. Bail bond, furnishing of bail bond. The contract between COT and court. So you have to produce the accused on that day. That is, if he fails, then proceeding under section 440 will start.
No. First is the writing with the signature. Be afraid. That we do not. Why know the currency is not possible. Does not undertake to fingerprint it. Hence corresponding to the value we to this. One is one signature fingerprint. What is the prayer?
What is your prayer before our bench?
মাই লর্ডশিপ এই সমস্ত বেলবন্স থেকে আমার বাবা পেজ সরিয়ে দাও যদি এই
Can
সিগনেচার
it be done in the writ jurisdiction? এটা কি রিটে পসিবল?
আমি যেহেতু করি নাই আমি একটাও করি না
বুঝলাম, সেটা তো গিয়ে ওখানেই তো প্রসিডিং এ গিয়ে বলা। এখানে কি করবেন?
অ্যান্ড মাই লর্ডশিপ যে করেছে তার পানিশমেন্টও চাই, কারণ সে আমাদের উপরও প্রচন্ড অত্যাচার করেছে মাই লর্ডশিপ এতদিন
সেটা যখন আপনি জানেন যে কে করেছে তখন আপনি গিয়ে বলছেন না কেন কে করেছে? আপনি নিজে বলছেন যে ও অনেক অত্যাচার করেছে, তার মানে তো আপনি চেনেন যে কে করেছে।
আমি আমাকে যে ইনফরমেশনটা দিয়েছিল তারপরে আমি সেই অনুযায়ী অ্যাকচুয়ালি সিজিএম ফার্স্ট টাইম রিট কোর্টে একবার সিজিএম এর কাছে রিপোর্ট চেয়ে পাঠানো হয়েছিল। সিজিএমও বলেছে যাকে আমি অ্যারেস্ট করছি, আমি প্রেয়ার্সে করেছি, তা সে এই ম্যাটার্স গুলোর মধ্যে অ্যাডভোকেট হয়ে দাঁড়িয়ে আছে, মানে তারই মামলা, বাট সিওরিটি signatures has been forged. That is my allegation.
কে করেছে ফোর্জ? আপনি বলছেন যে অত্যাচার করছে, তার মানে আপনি জানেন যে কে করেছে
Yes,
ফোর্জারি?
my lordship.
কে করেছে?
Kaushik Bonik, I arrest him in this petition or writ petition or prayers.
কে উনি কে?
An advocate of Alipurduar Court, practicing lawyer. But my lordship, that
আপনার সঙ্গে কি আছে সম্পর্ক?
my lordship, আমার বাবার বড় ভাইয়ের ছেলে, মানে আমার হিসাব মতো দাদাই হয়, বাট ওনার সাথে আমার সাথে
দাদা।
ইয়েস, বাট ওনাদের সাথে আমাদের দীর্ঘদিন যাবতীয় কোনো রিলেশন নেই মাই লর্ডশিপ।
You filed an FIR.
My lordship, FIR I filed.
Whatever it may be now, what is your prayer right now?
My lordship, he's
Who is for the state?
I
do something for them. It's a serious fraud and a serious forgery. You can't remain a mute spectator. If this is a scam, then this has to be unearthed.
If forged document is filed before a court of law, court can take up the issue under section 340 of CRPC.
So direction was given.
The forged document submit
was given liberty.
What appropriate forum? Now it appears is a larger issue is something else. What is happening? Did you realize? Have you seen the report? The report says that all those signatures which have been incorporated therein does not match with his signature. Who has done it? It's a serious scam which is going on. Why not the court wanted the surety to remain personally present before it? ওটা কি হয় সিউরিটি
বন্ডের
পার্সোনালি ওখানে দাঁড়ায় before the court satisfaction of the ECGM
না
সেখানে কি
ওখানে
করে?
ওখানে ওখানে থাকে একটা মানে স্টাফ থাকে রেজিস্টার থাকে ওদের যতগুলো ধরুন 5,000 টাকা দিল ওর একটা অ্যামাউন্ট থাকে সেই 5,000 টাকা থেকে ওটা ডিডাকশন হয়ে গেল মানে ও আর এতটা টাকার মধ্যে সিওর মানে সিজিএম এর স্টাফই থাকে
But এই যে satisfaction যেটা হচ্ছে satisfaction must be that he is a person who stood surety.
সেই কোর্টের স্টাফ তো থাকবেই মানে ওই যে রেজিস্টার
When he is not there.
he is not there.
Huh?
The staff, the bail bond register is maintained by the staff of the CGM or ACGM, whatever it may be. CGM কে দেখতে বলেছে
মাই লর্ডশিপ এই কোর্টে এসেছি মাই লর্ডশিপ আপনারা একটা ভালো ডিসিশন নিয়ে আমাদেরকে পাঠান আমাদের অবস্থা খুব খারাপ মাই লর্ডশিপ এটার জন্য যে আমাদের পিছনে কিভাবে লোক লেগে আছে মাই লর্ডশিপ আমি বলে বোঝাতে পারবো না।
This bail bond was এই কোথায় দেওয়া হয়েছিল এই বেল বন্ড গুলো কোন কোর্টে
দাখিল হয়েছিল বেল বন্ড গুলো সিওটি যে দাঁড় করানো হয়েছিল সেটা কোন কোর্টে
আলিপুরদুয়ার সিজিএম at আলিপুরদুয়ার
CGM
whatever it may be now CGM
And my lordship, আমি একটা জিনিস কোর্টের নজরে একটা জিনিস আমি আনতে চাই মাই লর্ডশিপ আমার স্টে অ্যাপ্লিকেশনে পেজ নাম্বার 87 মাই লর্ডশিপ পেজ নাম্বার 87 এই রিপোর্টটা রিট পিটিশন চলাকালীন ফাইল হয়েছিল মাই লর্ডশিপ সেকেন্ড প্যারা মাই লর্ডশিপ একটু সেকেন্ড প্যারাটা দেখুন
who is a private respondent serial number 8
yes my lordship I arrest him but I don't know with him who is combined or not I didn't know
who is representing respondent 1 what is this
you are keeping mum
what are you doing you are a very no you are a responsible member of the bar kindly visualize the situation
Earlier report and we have this report which has been called for by the court.
now it's a high expert committee look at it what is happening
Maybe if you are my client it's at fault maybe but I am
in এই যে সিউরিটি যেটা ওনার আপনার বাবার নামে যেটা করা হয়েছে এটা কি সবকটা ম্যাটারে যেখানে উনি অ্যাপিয়ার করছেন বা অন্য ম্যাটারেও করা হচ্ছে
my lordship আমি বুঝলাম না
উনি সবকটা ম্যাটারে অ্যাপিয়ার করছে কিনা
সেটাই জিজ্ঞেস করছি মানে যে কটা ম্যাটারে উনি অ্যাপিয়ার করছেন ওই সব ম্যাটারে আপনার সিউরিটি ওখানে লেখা হয়েছে
yes yes my lordship
what is happening
yes my lord this report filed by CGM my lordship in this report
what is this happening where is your client we are directing the police to take an immediate steps no definitely not this is really I would say true
my lordship in this
this is
Well, I am for 232, my lord. Well, I am for 232, my lord.
232.
Well, I am for
232.
232. Well, I am for 232, my lord. Well, am I audible?
Next. 232 knee Q. 233.
Well, I am for 232, my lord.
Lordship, I'm on behalf of the applicant, Lordship. Lordship, as per order dated 16th of May 2024, it was directed to Siliguri Municipal Corporation to submit report. But till now, no report has been submitted to the court, Lordship.
Wait for the Siliguri. Who is representing Siliguri Municipal? Mayor, you are representing Mayor.
You are representing the Siliguri municipal. Why you have not demolished it? No. And submit the report whether the unauthorized construction noted in paragraph F of the demolition order has been demolished or not. In the event respondent number 6 finds that unauthorized construction as afforded has not been, it is open to them to demolish them. What you have done, tell me.
He inspected the certain portion of the property, but the another portion was profitable under blockade. He could not inspect. He could not find that inspection.
Why? It was under whose lock and key?
The respondent who is the tenant who is staying there, he gets the.
Is he a party here?
Lordship, at the day of inspection, we were not informed. Even at the day of hearing, we were not informed, Lordship. And even they have not submitted the report till date because it was a direction was given.
Who has come up?
They have come up in the.
Who is he? Who are you?
Lordship, on behalf of the applicant, Lordship.
No, appellant I know, but who are you means the landlord or a tenant or what? And why this order is passed? You wanted the implementation of the order of demolition.
Lordship, when the inspection was made, Lordship.
I am asking you, madam, very simple case. You have come because why this order is passed, I want to ascertain. You have come seeking an implementation of an order of demolition passed by the municipal corporation.
Yes, Lordship.
That appears. So you must be the owner of the property, otherwise nobody would come. So where is the
You challenge the order of demolition.
Yes, Lordship. Lordship, kindly give me 1 day accommodation, Lordship.
So why you have
Lordship,
started your submission?
Yes, Lordship, but actually from today morning, I'm not getting my brief, Lordship. I have
what?
noted all the points over there, but today, unfortunately, I'm not getting the brief from the morning. I have
Why?
all the other briefs, but this particular brief I'm not getting. I just need 1 day accommodation, Lordship.
You know where you have kept that brief?
Yes, Lordship. It was in my bag, Lordship. I have multiple other briefs, but Lordship, I'm not being able to find this particular brief today. I just need 1 day accommodation, Lordship.
You may not find it tomorrow also.
No, Lordship. By tomorrow morning, I'll be with the brief, Lordship. I have to find
You
in my
know where you have kept the brief.
Lordship, it can be in my chamber, Lordship. I have to see, Lordship. Just 1 day accommodation, Lordship. Just 1 day accommodation. By tomorrow morning, I'll be there with my brief, Lordship.
Oh, they have come up challenging the order of demolition.
Yes,
Oh, now I got it.
Lordship, if this
Why
matter,
she is so much vocal?
Lordship, if this matter is kept on top of the list, then also I'll have no problem.
but we have problem.
Because it will be kept at the top of list, but your property would go at the bottom. So, it will come, it will be grounded. If you make an unauthorized construction, no. Yes, top of the list tomorrow at 2 p.m. Do it
Grateful, Lordship. Grateful, Lordship.
and come with the inspection report. Yes, next.
My lord, in item number 234,
This call,
I am appearing for the petitioner. Item number 234.
no, Thursday week.
But I appear for the petitioner. 234.
Yes, next.
I'm led by Mr. Inulak Mitra, he is in the virtual mode.
But I appear for the petitioner. With my learned junior, Mr. Nobang Tulpal.
At the very onset, I'd like to place my affidavit in opposition with respect to the stay application. With respect to the CAN application.
Reply.
And
But order impugned under
You
challenge
can't
is at
hear
page-
him. I can't hear him.
I was served by the copy of the CAN application along with the annex.
My lord, am I audible to my lord?
Why, copy was not served.
I have informed the respondent.
My lord, am I audible to my lord?
No.
Am I audible?
No.
No.
Well, I'm filing an opposition to their application for filing, adducing additional documents and.
Have you file your reply?
And reply.
What is the dispute?
With regard to the authority who has terminated my service. The
Discharge from service.
disciplinary authority who has terminated my service was not the disciplinary authority, but the appellate authority. So my right of appeal has been exhausted, madam. Yes, you're audible now.
Yes.
My lord, am I audible?
Yes, now.
My lord. Order impugned under challenge is at page 227.
No, we have already read the order.
My lord.
Yes.
My lord, service petitioner before your lordship
Yes.
was a clerk cum cashier. The service condition of the petitioner is governed and regulated by Uttar Bongo Kshetriya Gramin Bank Officer and Employee Service Regulation.
What stay you expected from this application, sir?
My lord,
Your
the
writ
order-
petition is dismissed. The punishment has already been inflicted. What stay you expect in the application, sir?
It is final hearing stage, my lord.
This is not a hearing stage. This is the application stage. So application may be disposed of. File your paper book, sir.
Paper book?
Yes, obviously, it's a hearing.
But give some time, I will file paper book.
Yes, please. Lako. We are disposing of the applications. Nothing more than that. Nothing remains.
Lordship, with respect to CAN 2, Your Lordship, wherein I have prepared with the leave by the Honorable Justice.
What can do?
CAN 2, I have adduced, I have filed one additional document.
You wanted to rely upon an additional document. You are a respondent. Okay.
I had preferred that CAN 2 upon the liberty granted by Justice
But
Jagannath.
kindly hear me first, then my lord.
No, that you will file. You have filed your opposition to that.
Yes.
Yes, we'll see to it. Don't worry. I'm stating the CAN 1. This is CAN 1 which is appearing. Lako. The instant application is filed seeking stay of the operation of the judgment and order dated 25/1/2024 passed by the single bench in WPA 950 of 2023. Stop. the writ petition was filed assailing an order of the disciplinary authority by which the penalty
My lord, chairman is not my disciplinary authority. This is my humble submission.
just 1 minute. I'm just looking at the ultimate penalty.
Removal from service.
Oh, the petitioner was inflicted the penalty by removals from service.
By the chairman who is not the
Just
competent
removal
authority.
from service. Full stop. It is contended by the petitioner that the authority who inflicted the punishment or the authority who conducted the disciplinary proceedings is denuded of any power nor competent to do so, and therefore the judgment the punishment inflicted upon the petitioner needs interference. The single bench, after
Available only
deliberating
one
upon the
paragraph.
facts, deliberating
Paragraph
upon the
21.
facts and the laws
Law has been not been properly dealt.
as understood, dismiss the said writ petition. The intra-court appeal has been admitted, and therefore the parties must be given an opportunity to be heard to argue the instant matter. Since the punishment has already been implemented by removal of the service, and the writ petition having dismissed, we do not find any ground for passing an interim order as prayed for in the instant application. The order of dismissal of the writ petition cannot be stayed, as it would be of no consequences. We thus do not find that the prayer made in the instant application can be granted to the petitioner. Accordingly, the application being CN 1 of such and such is hereby dismissed. So, Can 2 of 2024. This is an application taken out by the respondent seeking to adduce additional evidence. The parties have already exchanged affidavits, and therefore the said application is otherwise ready for hearing. Since the application for additional evidence is required to be heard along with the appeal, along with the hearing of the appeal, let such application be taken up at the time of hearing of the instant appeal. So the appellant is directed to prepare requisite number of paper book.
Informal paper book, my lord, kindly.
Informal paper book. Informal paper book within
4 weeks.
Within 4 weeks from date. So let the appeal along with Can 2 of 2024 be listed before the available circuit upon expiration of upon filing of the said upon filing of the paper book.
In my paper book, should I annex the stay application also?
If you so want, this is the freedom is with you, sir.
My lord, kindly.
What is the necessity, sir? What is there in the record that is to be done? Anyhow.
Within 4 weeks, I will file paper.
Yes, please.
Informal paper book.
Yes, next.
What is a small indulgence, my lord? Well, in item number 232, my lord, I was appearing, but I was not audible, my lord.
What can be done, sir? Anyhow, we have made a passover. Next.
My lord, I'll be waiting.
Next. Who is appearing? one, what is the name? Pooja Maya. What is the name? Yes, Pooja hi to. Anyhow, Passover করো আজকে প্রথম দিন যখন ধরছি তখন। Next.
Item number 236, Mr. Partha Pratim Roy will be appearing on behalf of.
But item number 236 and 237.
Well, in this 236 and 237 is for the match number 60. I am for the appeal and along with an application for leave to prepare an appeal. Because we filed an application for addition of party before the court, before the honorable sitting judge, but without disposing of the same, the order was passed. Challenging the said order, we filed an memorandum of appeal along with the leave to prepare an appeal. Because we are also the interested parties, we interested of the outcome of these.
The order under appeal was passed in my writ petition where we assailed police overaction. There, the challenge was to an order under section 144 also. The 144 order has been set aside with very scathing remarks because what has happened, I'll indicate that, and 2 other reliefs were there. Those reliefs, although was mentioned, but they were not granted or considered. So we've been constrained to prefer this appeal and the application to that. Now 236 is the appeal that files for leave to appeal. Lordship will just give me a minute. No appeal for leave to.
So, yes.
236.
Yes.
Private respondents who wanted to get themselves impleaded in my writ petition, they have filed 236 with a leave to appeal.
Yes. What is
And
their grievance? This order.
Yes, well, that's the first point. So 236 emanates from an order which was passed in my writ petition, which sets aside an order passed under section 144, dated 4th May 2024.
Yes.
So in any event,
Can a writ be extended to that extent to set aside the order of 144?
Yes, that's the learned single judge had put this question. We had relied on
Yes.
that judgment. I'll be able to
Show us
that
which judgment you have relied upon. Let us see that how far
Yes,
the
but
writ
I will be-
jurisdiction
I will before that-
can be spread over or extended. Let us see.
To set aside an order under 141, I'll play for only one indulgence.
What? You show us. I do not
Yes,
find
yes, I will.
anything.
But Lordship will allow, this was a very hotly contested matter. There are a lot of respondents, allows me to come physically, keeps it any
Yes.
day next week. my lord.
Before us, it is always a cool contest. There is no hot
that is
contest.
true.
So
I
it's
am
a cool
aware of
contest.
that.
Come on.
But me
argue.
physically present will just give me that little bit of satisfaction. Keeps it on the 10th or the 13th. Not if it
No.
Kindly, my lord, I'll come over and do the matter. Please, that much indulgence. On the 10th or the 13th, either of those two, please. my lord, please.
No. Then it can only be listed on 9th.
That
No,
one
not
more
beyond that.
extra day gives me, I'll come on the 10th, please, my lord. I'll
No,
not be able to
we
go
can't.
from here.
Because our principle is that we dispose of the matter in the circuit bench itself.
No,
So
10th,
we
your
can't-
lordships are
we
there till
can't.
the
Sorry,
13th.
the last day is 13. We can't do it.
So
We can
10th lordship
fix
keep
this
it, my lord.
matter. We can at best fix this matter on 6th Friday. We can accommodate you for 2 days. Come on 6th.
Very well, my lord.
Yes.
So my application is concerned,
May I
my lord,
just
for
Come on
the
6th.
appeal.
Let this
Could
matter
I-
be listed on 6th.
Parthad, act a minute. Lord, could I just one minute make one request? Please, could I just renew my prayer for the 10th? Lord, I'll be in some difficulty to leave here.
No.
I'll finish on the 10th. Lord, I know this bench,
No.
it will not take more than 15
No,
minutes.
6th. 6th is the best day.
Well, there are matters.
You do it virtually. Where is the difficulty? Do it virtually. Do it virtually.
2 days keeps it on the 10th. Not why? Unless you're not just doing this to me. Keeps it on the 10th.
Not 10th. No, 6th is the best one. I think 6th is a.
No, I'm sure it's but it's just.
Have a pleasant weekend.
আরে জোর করে তুমি বদমাশি করছো।
Yes.
Have a pleasant weekend.
Even he wants 10th. Please keep it on the 10th.
10th would be convenient.
I would have been in some difficulty. I would not have haggled
I'm
like
led by Mr. Rai, but 10th would be convenient for me also.
Then everybody is saying, unless it would have been inconvenient, I would not have happened like this.
Inconvenient for us.
Millard, I'm
Come
saying
on,
this,
10th.
Millard,
Come on, 10th.
Millard, with leave of Mr. Ray Millard, I'm led by him. Millard, in 236, Millard, our stay application, Millard, we have affirmed, Millard, I am serving it right now upon Mr. Banerjee's junior and Millard upon the landed.
Give it.
And Millard, in
The only point which we will be considering on that, whether the writ jurisdiction can be invoked in this regard. That's the only point. Let us see. Let
Yes.
Mr. Banerjee satisfy us on that point.
That was the point we raised before the trial court.
Yes, the learners, I'll come, Millard. Your lordships have been very
And it is
kind.
the suo motu point
Okay,
raised by the bench.
So far, my additional point will be related to the immovable property. In respect of which we have taken over the title.
The order dated the last, Millard, the 22nd August 2024. Where the last day of the circuit, because of their urgency, matter was taken up. Where that there is the observation that late police do not take any coercive steps against the appellants, whatever, Millard. What is the problem, Millard? It is the alluvial land. And there is no right.
Let him not raise these issues. He had made the submission before the learned division, before the honorable division bench, saying police is not doing anything. For 3 more days, it can stay. I'll come on the 10th.
The problem is that every day they are lodging a complaint.
Come on, 10th. We are ready with that. Let him. Yes.
So whether the interim order can be passed in absence of any prayer to that extent. Can you consider?
So we have to also justify the stand of the state as well.
Yes.
Your lordships are very kind. We'll come on the 10th.
Yes, let it on the prayer of the parties. Let this matter be listed on 10th.
Time may be fixed for 2 p.m.
What? It is always at 2 p.m. You have suggested in yesterday that from 2 p.m. you take up those matters.
Grateful.
And then you were saying.
This is what is happening. This is what is happening. Yes, call the next.
The single bench, Millard.
Yes, next.
So we are ready.
You are not there.
Huh?
Yesterday you are not
No,
there.
I was not there, Millard.
Why?
Yes. $238. Just imagine. Just imagine. Not today, next.
Dr. Dennis on the case, I am led by Advocate on the record, Arun Kumar Chakraborty. The service is not holding.
Let us see. They are appearing. What do you want? What more you want?
Without service there.
We are appealing, Millard. Well, I am appealing, Millard, for respondent number 5 and 6. 6%.
Why you did not cure the defect last time? The court directed you to cure the defect. It's a minor defect and you are not finding time to remove it. Instructed, then we are passing an order. No, sir. Where is he? Then let him engage, your client engage and another advocate. Sorry, we can't. You can't dictate or run the court. You're saying, yes, an accommodation is sought. You are representing whom?
Not today, not
5 and 6
Yes.
respondent number. 5 and 6.
Respondent number?
5 and 6.
For B.Ed Training College.
Yes, I'm the college.
And this educational trust.
That's right. Trust.
And what about the state? Yes, state. So you can represent the district magistrate Alipurduar. No difficulty. BLLRO you can represent. You can registrar of firms, you can do it. Additional district sub-registrar, you can do it. Then where is the,
The university.
where
has
is the, where is the ESG?
Huh? But, additional. Yes.
ESG,
Additional.
Additional Solicitor General, where is he? DSG, oh, I do not.
It's not there in the.
Because the income tax departments are there, so he can represent those.
But kindly have a look at the order impugn. Probably details of the income tax department may not be required at all. So have a
So
look at the inquiry.
why he has been made party? If he is not required?
But it requires a
If he is not required, then why
on
you,
everything which the
then why you have
secretary has
made
said
party?
that this is absolutely a private dispute.
Then why you have made party?
You wanted, we are granting you an adjournment eternally, don't worry. We are granting, no difficulty. How much time you require? No, you take it for 3 more circuit you can surpass, we can give you. January next year? I've seen the order. Nothing. Anyhow, you want a January? Where is your advocate in the court? Tomorrow? Well, the next matter.
नहीं.
Next. How many days?
For this state.
Yeah, for the response. Yes, you can want to letter. This is an application for condonation of delay in filing the appeal. It appears that there is a delay of 5 days. Full stop. After perusal of the amendments made in the instant application and upon hearing the respective counsels, we find that the explanation so offered constitute a sufficient cause, and therefore there is no impediment on our part to condone the delay. Accordingly, the delay in preferring the appeal is hereby condoned. The application is thus allowed. What is this can do? What is the suit for? What is the stay application?
First, order issue, page number 210, relevant page is page number 216, paragraph number 8.
So the illegal constructions or the plan is kept at hold. It kept at hold,
Lordship,
on hold.
Lordship.
What is the stage of the civil suit?
Lordship, it is in the evidence stage and the DW is going on. Defense
So means the plaintiff's witness, the evidence is closed.
Lordship.
So complete it.
So I am the defendant in that suit.
True, complete your evidence, give your evidence.
Lordship, the original defendant died and they took several years to substitute the defendants during this COVID
Why
period.
don't you come forward and why didn't you come forward and substitute yourself in the suit?
So we were unaware actually. Our father used to look after that shoot, and we are actually unaware about that shoot. And subsequent to the death of my father, my lord kindly takes up the playing of that shoot and the written statement.
The single bench has really protected your interests.
My lord, actually,
In fact, because there is already a dispute which is really going on in respect of a passage.
My lord, I appreciate
And
that.
the cancellation has been kept at hold so that at least.
Lordship, I am not agreed by the cancellation. My lord, the
You are not
construction.
agreed, then why you filed a writ petition?
Lordship, my construction has also been stopped.
If the plan is cancelled, then what? Then not only the construction shall be stopped, but it should be demolished immediately.
My plan should not be cancelled.
So that is why I say that the cancellation is on the ground that there is a dispute on the passage, which you have shown to be your passage.
No, Lordship, actually, the crux of the matter is the plaintiff and the defendants are the brothers.
True.
And they were using that common passage. That is for their mutual use.
Now
And-
this, you may have shown it as a common passage. Your
Lordship,
brother
I have
may
shown
have claimed the exclusive passage.
No.
What to do?
They are also saying it is common passage. I am also saying it as
Then
common
what
passage.
for the suit is there? What adjudication in the suit is going on?
Lordship, they have claimed it to be a 9 feet wide, and my claim was it is a 6 feet wide road. And on that basis, my plan has been cancelled.
No.
As I have applied for the plan, claiming it to be a.
No.
Lordship, kindly.
Plaintiff is claiming it to be a 9 feet wide. They are claiming 6 feet. The injunction is granted over 9 feet wide. Now they have come up against a representation with the corporation that they have suppressed the fact. They have submitted a building plan.
Okay.
They have transgressed into the common passage.
Question
Now
of
on
suppression does not arise, my lord, because the corporation itself is a party to that suit. And corporation after.
Then let it be decided. The cancellation is kept at hold. I do not think there is any problem. I think the substantial justice has been given. Otherwise, this cancellation.
I may be
the
permitted.
cancellation
My lord.
would remain. And if you won, then again you'll have to go and make an application for re-sanctioning of the plan, because by this time, everything will go. So they have kept the order of the cancellation into abeyance. That means it would remain the moment it goes, your plan would be revived.
I am not
have to pay any more money for that.
My lord, my prayer is very simple. For the time being, I may be permitted to complete my construction, which is incomplete now, and I have invested
And
a lot of money.
ultimately, if it is found that this is not a 9 feet, it is a 6 feet,
Then my claim establishes.
then how can no?
If it is found to be a 9 feet.
You are claiming 9 feet.
He is claiming 6
6
feet.
feet. He is claiming. Suppose if he won 9 feet, then what will happen?
That can be taken care of by making it clear that it will depend on the fate of the suit. If I lose the suit, I will demolish the entire construction.
Give an undertaking that in the event it is decided against you, you will not approach the court and want any stay. Give an undertaking.
Are you applying that?
Give an undertaking that is what? Like that you will not approach them.
Lordship, I will take instruction in this and I will come back tomorrow, Lordship. With that undertaking, if possible.
Nothing.
My lord, kindly give me one day explanation. I will take that instruction, what has fallen from my lord.
Nothing, that is not a passing remark. Never believe the version unless it is reflected in the order.
My lord, merely on the basis of an injunction where the passage, wide of the passage has not actually been decided, my lord.
That is relevant. The present appeal arises from an order dated 14/6/2024, passed in WPA number 1153 of 2024, by which the order of cancellation passed by the Siliguri Municipal Corporation and the demolition of the alleged illegal construction was kept in abeyance until the final verdict is passed in the civil proceedings. Admittedly, the plan was sanctioned by the said by the Siliguri Municipal Corporation in favor of the appellant for construction of a building or slash structure, showing that on one side it is abutted by a 6 feet wide common passage. Subsequently, the adjacent owner of the said common passage claimed that it is a 9 feet wide common passage, and taking advantage of the sanction of the building plan, the petitioner has encroached thereupon by making construction. A civil suit for declaration in this regard is filed by the said adjoining owner, who happened to be the brother of the present appellant.
Uncle of the
Before he was which is still pending. Who happened to be the which is still pending. So in course, the aforesaid facts was brought to the notice of the single bench. So the aforesaid fact was brought to the notice of the commissioner of the said municipal corporation, who, after taking into account, cancelled the said sanction plan. As a resultant effect, the construction becomes illegal. So, apprehending the consequential steps to be taken by the municipal corporation on cancellation of the said plan, the appellant approached the writ court, seeking mandamus, seeking a writ of certiorari to set aside, quash the order of cancellation passed by the commissioner, Siliguri Municipal Corporation. So after noticing the fact that a civil suit in relation to the alleged common passage is pending before the court, the single bench kept the order of cancellation as well as the demolition of the construction to be in abeyance till the decision of the civil suit. The appellant submits that he should be permitted to complete the construction, to make the construction. And in the event it is found that the said common passage consists of 9 feet width, is comprised is of 9 feet width, and not the 6 feet width, the appellant would take steps to restore the same. Such such stand does not appear to us have any substance, for the simple reason that the order of cancellation is staring at the face of the appellant, and nobody would be permitted to make constructions without the approval and or sanction of the competent authority. Permitting the appellant to make the construction on the teeth of an order of the court shall have the wider ramification, and the situation may become irreversible at a stage when the civil suit is finally decided. We have been given to understand that the suit has matured enough and the evidence on the part of the defendant, that is the appellant's side, is going on. Full stop. We therefore expect that the civil suit would come to its logical end at an earliest. We thus do not find that the order passed by the single bench warrants any interference. Appeal and applications both dismissed, no order has to be used.
Yes, my lord.
Well, the next.
Lordship, state has preferred this appeal.
Yes.
State has preferred this appeal, Lordship, against being agreed by an order passed by Honorable Single Judge on 22nd 5 2024. 22nd May 2024. Before I proceed, may I say something regarding the actual fact of the case in nutshell?
Why the state will come?
Lordship, it is the investigation.
No, it is when there is a dereliction on the part of some of the officials. The state should not stand by their side.
But Lordship, I have two-fold submission.
Let them come, I can understand, but state is coming, I am really surprised.
No, why state is coming, Lordship, may I explain? As because the freezer of the account is there, investigation is being hampered, because Lordship, this case affects this case relates
Sir,
to
the court has said that when there was a serious incriminating materials having unearthed, simply writing a letter without letting the magistrate to know what is happening.
Lordship, subsequently that has been done, but inadvertently that was not placed,
When the
Lordship.
court activated, then you have done.
No, prior to the order, Lordship.
Then why you did not brought it to the
That's the
notice?
problem, Lordship, because we have the case ready. It was inadvertently not placed before the Honorable Single Judge. That's the problem, Lordship. I'm coming to it, Lordship.
Where you have stated that it was done.
Which
to us in your application.
Lordship. For that, Lordship, sees 4, page 5.
Yes.
Investigation not reported the magistrate.
You have not challenged that disciplinary proceedings to be initiated, you are not challenging. That does not appear to be so.
Lordship, we are challenging, Lordship.
No, where? There is no abamement in the stay application.
Lordship,
Nothing you have said.
for page 7, Lordship.
Yes.
Not in that much, but modification on and there's these stringent conditions.
What?
Imposed upon the petitioner to furnish bond equal that is there.
Where? Page 7 of what?
Lordship, page 6, point number 5. Memo of appeal, Lordship.
That is regarding sanction.
No, this is the modified and stringent condition is imposed to furnish a bond. What are you, what is this?
Lordship, কোথায় আছে memo of appeal টা? The application. কোথায় লিখেছি এটা? Lordship, kindly take up the stay application, page 5, para 3.
But the grounds of the appeal have to first sustain. They cannot go beyond the grounds.
Show us the P2.
Stay application, Lordship.
Yes, you are referring paragraph 3, which contained an annexure P2. Where is that? Which page? P2 is at what page?
Lordship, page 10.
Yes.
We have the fresh copies also. Page number 5. Lordship, here, original.
Magistrate was not informed. Seizure to the magistrate was
Subsequent, Lordship, there were 6 investigating officers. The last investigating officer who joined in the 2020 during the pandemic, Lordship, present today, he informed the matter to the magistrate. And we have the copy, received copy also.
After filing of the writ application.
No. There is a within very short period.
No. That was not reported to the magistrate by the then investigating officer.
Then
we admit that. But Lordship, out of 6 investigating officers, a disciplinary action has been ordered against 3. Now, I humbly submit, Lordship, against the first one.
Just allow me to. Seizure was done in the year 2013
13.
and intimation was given to 2022 after 9 years.
9 years.
Good.
The spirit of section 102 is that when you are taking such a harsh step, you ought to have.
Lordship.
But you have not 8 years or 6 years.
Lordship,
How many?
Lordship.
9 years. What
Lordship,
you were doing?
that is the reason.
And then you wanted to take advantage of this.
No, Lordship. Kindly bear with me for a moment.
And what is the outcome of this case? Criminal case?
No, investigation is still pending as because.
For 9 years?
Yes, Lordship. We are showing Lordship.
12 years now.
As because
years.
the present investigating officer, he gave intimation to the department for the obtaining the sanction, because Lordship knows better than me that in a case of Prevention of Corruption Act, prior sanction is required.
How many officers of the corporation were found guilty?
Lordship, one DM was there. He was arrested.
To have been involved, how many?
Lordship, many.
Many. The corporation.
Siliguri Jalpaiguri Development Authority. Four officers.
This is municipal corporation, I think.
No, Siliguri Jalpaiguri Development Authority.
Siliguri Jalpaiguri.
SJDA. One DM, Godala Kiran Kumar, he was arrested even in this case. So, my point is that, Lordship, we humbly submit twofold submission. One is, Lordship, analysis para 18, page 10 of the impugned order.
Yes.
Lordship has seen the first fold is that the seizure, while passing an order of defreeze, the court did not, we humbly submit to the best of our ability and knowledge, impose any condition of filing any bond or bank guarantee.
The authority committed a violation of the statutory provision. And when somebody comes and complains that the authority have acted contravention to a law, then the authority say, I should be protected. Is this a law? If the 102 says that you have to immediately approach the magistrate having jurisdiction, and you sat for nearly 9 years and still expect the blessing from the court for your lapses, for your grievance.
Kindly appreciate, Lordship. 3 inspectors were, 3 persons were directed for departmental inquiry. But the fact remains, one, Sri Shopon.
Sir, we are not concerned with that. When you issued an order of seizure,
Lordship,
then the 102 says that you can,
Immediate,
not difficult, you'll have to do it. If you have not done it, Supreme Court has said that what is the consequence whereof?
Departmental.
What is the consequence whereof? Seizure will remain valid? I'm asking you.
Lordship, for delayed communication, seizure will not be vitiated, Lordship.
What's the law?
Lordship.
What's the law?
I'm basing the judgment upon which this order has been passed.
Please, the court for us.
Lordship. Lordship, send over this.
Please, sir, 100 is quoted. Where is the Shento Wagi?
Sorry, this is sent over. Lordship, kindly sees. May we start from Lordship? Lordship, the very first reader from para 19 onwards.
Just give me 1 minute there.
Lordship. Para 19, 20.
Just 1 minute.
Lordship.
Let us see. Para 19 you are saying.
Starting from para 19.
So page 7 is missing from here. But
photocopy. What you have done?
No, I have a copy from the Supreme Court itself.
Why you are not given a giving copy? The impugned order, page 7 is missing. My copy has, But my brother's copy, page 7 is missing.
The impugn order, Lordship.
Yes.
Lordship, may I give my copy? Okay. আর ইম্পিউন অর্ডারটা জাস্টিস রবের অর্ডারটা দেখে দিবি না এগুলো
And Tom, it's a directly point to involve. If you go to page 30 at the bottom.
30.
30 at the bottom. Or you can run page 11 at the top of the. তার আগে paragraph এর উপরে just
Everyone has allowed the claim of this penalty for defreezing.
Para 21.
You're citing this.
Para 21, Lordship.
Reasonable explanation.
So on the, so far as the freezing is concerned.
My lord,
Yes,
I wish to, my lord, put forth certain facts.
Para 33,
My lord, Shento Varghese' judgment differs completely on facts from the present case. In Shento Varghese, my lord, the crime was registered, the FIR was registered in the year 2022. My lord, kindly see para 13 of this judgment. Shento Varghese. Para 30, my lord, 30.
File your affidavits, but we feel that's the point it's required to be considered, and we will stay so far as the freezing part is concerned.
My lord, freezing should not be stayed, my lord. There's disciplinary action.
For the time being, we are doing it.
My lord, a writ proceeding, my lord, a writ is, my lord, pending on the basis of the, my lord, the order. My lord, kindly grants me an opportunity to submit. In Shento Varghese, my lord, the delay was of 20 days. In my case, my lord, it is 9 years.
No, that's right.
My lord, 20 days in Shento Varghese, my lord. It differs completely on facts, my lord. Kindly considers that point. In this case, the investigating authority has shown a completely lackadaisical approach in, my lord, investigating the offense. And my lord, I am the victim, my lord. My lord, I'll show it to your lordship from documents.
The defreezing has not been allowed.
Defreezing has been allowed.
Where it is? Only thing is that the
procedure has been
branch
vitiated.
manager, when he said, is vitiated. That's all.
Not only that, lordship, the Union Bank has, the Standard Chartered Bank has, they have already taken their money, but the Union Bank did not, and so writ is pending, lordship, and stay has not been granted in that writ.
Lord, kindly stays the disciplinary proceeding. My lord, my defreezing, the
Almost
for the
8
time
vitiating of the
just for the time.
Not big extra.
Just for the time. Or we can keep this matter tomorrow. If you argue it, we will decide it immediately.
My lord, I wish to argue.
Come tomorrow. Argue the main matter. We'll decide it. We have seen this judgment. Let us see what it has decided. Tomorrow as a continuing matter.
Grateful, lordship.